Yes.
Lordships, I beg to mention item 11, with the concern of the other side. I would like to file reply, my lord. So let the matter be listed after 3 weeks, my lord.
Item 11.
11, yes.
Yes, on the prayer of MSK Devi, learned counsel for the petitioner. Let this matter be listed after 3 weeks so as to enable her to file affidavit in reply.
Yes, ma'am. Highly obliged.
Lordship, I'd like to mention item number 10, Lordship.
Hmm.
We need some time to file rejoinder affidavit, Lordship. We have recently received it, Lordship.
Mr.
J.M. Gogoi on behalf of BD Goswami, Lordship.
It's a fixed matter.
Lordship, I have taken consent from the opposite party, Lordship.
Doesn't matter, it's a fixed matter.
We need some instruction, Lordship, and we are going to file it, Lordship. Some time may be given, Lordship. Petitioner has belonged from, Lordship, North Lakhimpur, Lordship. And there is a 75 petitioner, Lordship. So some time may be given, Lordship. Instruction is necessary, Lordship.
Not Lakhimpur is very far off.
So,
He's beyond the Assam.
not, Lordship, but so many petitioners, Lordship.
Anyway, Mr.
J.M. Gogoi, Lordship, on behalf of BD Goswami.
J.M. Gogoi, learned counsel, appearing on behalf of Mr. B.D. Goswami, learned counsel for the petitioners. Lest this submits that he may be granted some time to file affidavit in reply. Prayer is accepted. Let this matter be listed for 3 weeks. Huh?
2 weeks, Lordship.
Yes.
2 weeks,
3
Lordship.
2 weeks, and then to make it 2 weeks.
Obliged.
To the Lordship. Lordship, with the consent of the other side, I beg to mention item number 17 to 63, madam.
17 to why?
File affidavit, madam. Today we are going to file this affidavit. madam.
Today?
And
What is this transfer matter?
That's why they wanted to they'll file affidavit today, my lord.
Why? Transfer matter, why affidavit is required? What is your stand?
according
We'll
to them,
dispose it off.
madam.
We'll dispose it off. Dismissing the writ petition.
Let them file. Let us see what is there in the affidavit, my lord.
Tell us what is your stand.
Madam, according to them, DC has not the power, madam. According to us, madam, DC has the power to issue the transfer order, madam.
Your stand is DC has the authority.
Right.
Is the competent. Authority competent to transfer. Under which law? Which rule?
Transfer Act, madam, 2022, madam.
Yeah.
As per our, my lord, stand, my lord,
Huh.
the order of the DC is without jurisdiction,
Huh.
void ab initio.
Huh.
So my lord, let them file the affidavit today and we'll, my lord, your lordship can have it after 2 weeks.
So if the transfer policy, authorize the deputy commissioner to transfer, what's wrong?
But I don't think, my lord, it is,
She said so.
but that is why, my lord, let the affidavit come, my lord, let us see.
Okay. 17 to? There's an interim order
There's an interim
operating in your favor.
Not in all the cases, only in some cases.
Okay. MS SUT Learned Council, Learned Standing Council,
Elementary education.
Elementary Education submits that required affidavit as directed by this court. Requisite affidavit, nah, in opposition as directed by this court would be filed during the course of the day. Therefore, press for listing of the matter after a week. After a week. What is transfer matter? Operation, it's the rationalization of the thing. Teachers, right?
Teachers.
Mr.
A.K. Burwa, my lord.
A.K. Barwa, Learned Counsel for the, in all the cases.
Not in all the cases, only majority of the cases.
And who else?
They are within, madam. I have taken consent, madam.
J. Abedin.
J. Abedin are present, huh? Learned Counsel petitioners are present, huh? Considering that considering the nature of the issue involved, which is no, considering that the matter pertains to transfer and posting of teachers
Teachers.
by the Deputy Commissioner of the concerned district, Deputy Commissioner of the districts,
Hujai district.
who alleged to have no authority to issue transfer, the authority to transfer the petitioners. Let this matter be listed after a week. As submitted by learned standing counsel, let the affidavit be filed during the course of the day.
But
Listing according.
interim order in respective cases may continue.
In interim order passed in the writ petitions, wherever no sorry, wherever interim order is passed in the writ petitions, same shall be continued till the next day.
Then maybe take up it on 7, madam.
7.
7
7 of what?
April.
April, madam. Tuesday.
No. After 1 week, we'll decide. We'll decide.
My lord will fix a date.
We'll see after 1
My lord. Obliged.
Your Lordship, I beg to mention 2 writ petitions for
Hmm.
listing in admission column, Lordship. For listing, Lordship, writ petitions,
Who is the, when?
any date as per the convenience of the
After 2
Honorable.
weeks.
Must oblige, Lordship.
May please, Lordship. Lordship, I beg to mention item number 59 of the daily, Lordship.
50?
59, Lordship.
And
Lordship, pass over the photo, Lordship.
why?
So, conducting counsel, Mr. M. Kolta has some personal difficulties to Lordship.
Here, Mr.
J. Hatimuria.
Learned counsel, J. Hatimuria, learned counsel but petition submits that the leading counsel in the matter has some personal difficulties today. Therefore, prays for listing of the matter after 3 weeks.
Yes, Lordship.
Praise the Lord, list after 3 weeks.
Obliged, Lordship.
May it please your lordship, I beg to mention an item to be listed, your lordship. The matter pertains to incorrect date of birth, your lordship, and the petitioner seeks to attempt various competitive exams but is unable to do so due to the incorrect date of birth. Your
Next week, after a week.
Obliged, your lord.
Please, your lordship, I beg to mention a writ petition for listing in the admission column.
After a week.
Much obliged.
May please, your lordship, I pray for listing a motion matter, lordship, Wednesday, lordship. Obliged.
Please, lordship. Lordship, I beg to mention 2 writ petition for withdrawal, lordship. Can it be for tomorrow, lordship?
Withdrawal tomorrow,
Obliged, lordship.
No, item 1 and item 7 are connected, my lord. Lordship may take up both the matters. One is a contempt and item 7 is a writ, my lord. It's a fresh writ.
Item 7.
Yes, my lord.
Okay. We'll take. The next call the next one. We'll take up with along with 7.
Yes, my lord.
We'll when the
Yes.
My lord, first.
Yes, my
when
lord.
we take up item 7, we'll take up that.
All right, very well.
Item 2.
May it please your lordship.
Where is it the order?
Order is lordships, original order passed by your lordships, my lord. But second one is might
Is
be
there any,
covered.
is there any duplicate order?
No. This is covered order, my lord.
Then,
Page 86.
ah,
The judgment and order dated 7/4/2005 dispose of WPC 3224 with
Hmm.
the following direction. Accordingly, the responsible authority, namely the Secretary to the Government of Assam Secondary Education Department and Director of Secondary Education Assam, as well as the AHSCC, are directed to consider the case of the petitioner within a period of 3 weeks from the date of the receipt of the certified copies of this order. And original order is lordship kindly there is a long order passed by your lordships. So in this case, notice may go.
is it within time?
Yes, it is within time.
Heard MS so-and-so, K. Devi, learned counsel for the petitioners. This is an application under section 12 of the Contempt of the Courts Act 1971, read with Article 215 of the Constitution of India and the Contempt of Courts within bracket Gauhati High Court Rules, bracket close 1977. Issue notice returnable by 4 weeks. And they learn counsel for the petitioners to take steps for service of notice upon the Alice contender number. Alice contemners. How many?
Lordships.
1. 2.
Yes, 1,
Alice contemners
2 and 3.
by split post as well as usual process. This after 4 weeks.
Apply.
You just make it steps within 3 working days. Yes.
Write them.
Yes.
My lord, this application has been filed against my lord willful violation of the order dated 19/7.
19/7/2023.
But my lord, certified copy that we received, my lord,
Hmm?
only on my lord 18/7/2025.
Huh?
18/7/2025.
25.
Page 29, my lord.
Page 29.
29, my lord.
Hmm.
We applied for the certified copy on 27/2023, my lord.
Hmm.
And it has been received only on 18/7/2025.
How it is possible? Why?
My lord, actually, we have submitted several representation before registry also.
Hmm.
Because of my lord, the order was not signed, my lord, at that time. That is why, my lord.
What is the direction?
My lord, page 32, my lord.
Shall bring it to the notice of the Commissioner Secretary Government of Assam and also before the
32.
Director. In spite of
Paragraph 13 and 14, my lord. Relevant.
the respondent in the secondary department in pursuance of the judgment or passed in the shall pay the regular so and so department if not paid in meantime. In addition to above, respondent shall also continue pay regular signature. You have brought to the notice of the commissioner.
Yes, my lord. That
When?
is page
When?
34, my lord, the next chapter.
When?
It is, my lord, 23rd July 2025, my lord.
Hmm?
Immediately after receipt of certified copy, my lord, that is on 23rd July 2025.
But there's no timeline.
There is no timeline, my lord. But I have not received my current and area.
Yes, heard Mr. So-and-so and counsel for the petitioner, same order. It is an application under section 12 of the Contempt of Courts Act, read the article so-and-so, so-and-so. Huh? The alleging, I said earlier, I didn't say anything, huh? Alleging willful and deliberate disobedience of the order dated 19/07/2023, passed in WPC number 5443 of 2018. Issue notice to answer. Same. Earlier, we have not mentioned that. Yes.
And the petitioner before list lordship, my lord, she is a subject teacher, my lord. And initially, my lord, she was appointed as the in-charge principal of the state school, school, my lord. And thereafter, my lord, private respondent filed a writ petition before the honorable court. And honorable court stayed my in-charge headmaster, and thereafter, my lord, page 39, my lord. Finally, that was in page 39 and operative portion page 47, my lord.
Page 47.
My lord. On para 15, on consideration fact that departmental inquiry is still pending before the petitioner, this court is of prima facie view that it might not be proper have the petitioner in charge until unless and departmental proceeding has been taken into logical conclusion. However, it has also kept in mind the petitioner case cannot be kept hanging just because of departmental proceeding pending not being concluded. Other guilt of so-and-so, so-and-so. In view of the above, the court is of the view that departmental proceedings should be continued and completed earliest positively within 2 months from the date of received certified copy order. In the event departmental proceedings not completed within a period of 2 months, certified copy order says respondent shall appoint the in-charge principal higher secondary in place of so-and-so, so-and-so. And my lord, without completing departmental proceeding, page 48. This is the so-called notice to the private respondent, my lord. And that departmental proceeding was still pending without any, my lord. And thereafter that impugn order has been passed, page 50, my lord, which is challenged before lordship, my lord.
No, this departmental proceedings is against the respondent here.
My lord.
But he was a writ petitioner.
My lord, I am
Earlier.
that time I am the respondent, my lord. I am the in charge head.
This is passed in his writ
in
petition.
his favor, my lord. And
Where
therefore,
does it say? In the event department is not complete in period of 2 months from date of serving of the state shall appoint a petitioner in charge.
Yes, my lord.
Yes.
at that departmental proceeding was not completed, my lord. That is, my lord, thereafter, my lord, there is a office memorandum. If the departmental proceeding is pending, he cannot, my lord, is a in charge principal. Thereafter, my lord, what happened, my lord, recently, my lord, during this, my lord, pending, honorable division bench ordered same issues decided by the division bench, my lord. Same, my lord, honorable single bench is the dear, my lord. Please make kindly see, my lord, para 17, my lord. 17 and 18, my lord. Para 17, my lord. Same issue, my lord. Please make kindly see, my lord.
You read page 50?
Yes,
Tezpur of so and so is hereby allowed to look up the academic, the affairs of.
yes, my lord.
Ah.
But my that order was not set aside by the honorable court till today, my lord. I was appointed by the director, my lord. And thereafter, my lord, though this is the hereby allowed to academic, but this is the administrative post, my lord. Your lordship go to the division bench order.
Earlier it was in charge principal.
Yes, in charge.
This is academic in charge.
But after all, these are, he cannot have a right. Honorable division bench says that he has no right even. If the departmental proceeding, your lordship go to the division bench.
No, this is with regard to
Yes,
same matter.
Same issue.
No, same matter.
Not same matter, same issue. Issue is in charge principal pending due to my department.
He has not been allowed as a in charge principal.
But honorable court says that if anything, my lord, is the administrative post, my lord. Please kindly say para 7, my lord. Same, my lord, is not permissible. Para 17, my lord, your lord.
7?
Yeah, 17.
In view of the respondent.
In view of the respondent one obtaining his B.Ed degree without taking prior permission of the inspector, he is without permission of the same school, and departmental proceeding has been initiated against him, and a memorandum of charge has been issued to him. The respondent one has also submitted his written statement of the defense of the memorandum of charge. As such, as on that there is a departmental proceeding pending against the respondent one. It is clear that whenever there is a pending departmental inquiry against a delinquent officer employee, the result of the departmental inquiry is to be kept in a seal cover, which is to be open only after selection process is concluded. A person who is not exonerated of a charge in a departmental inquiry cannot be promoted. In the present case, the respondent one cannot have any right to be the in-charge headmaster, as same is basically is a post to be held for administrative convenience till a regular increment is appointed to the post. Further, in the present case, there is a charge of misconduct made against the respondent one, for which there is a pending departmental inquiry. As such, it would not be proper for a person undergoing a departmental proceeding to be allowed to hold the post of in-charge headmaster, as the same is a kind of promotion, albeit ad hoc, temporary. When a delinquent officer is not eligible to be promoted to a higher post during the pendency of the departmental proceeding, the respondent number one cannot have any right to be the in-charge headmaster during the pendency of the departmental proceeding. In the above being said, we have perused the contents of the writ petition, writ appeal. The writ appeal, no PR has been made the respondent one in the writ petition. In the writ appeal is setting aside the departmental proceeding and initiated against also. In view of the reason stated above, we do not agree with the decision of learned single judge setting aside the impugned so by which the respondent four has been allowed to hold the post of in-charge headmaster. Consequently, impugned judgment and order so it is not suspended. He has no right even. It's a seal cover, my lord, because of the administrative post, my lord. I was appointed by the director. That was not set aside by the honorable court, my lord. A same honorable court, my lord, in single judge, this order has been passed, my lord. Now in division based, same, my lord. Same honorable court, my lord. And my learned friend also that time in the respondent.
That person has been promoted there before yesterday, madam. That person, this issue of
NOC has been NOC with regard to obtaining B.Ed degree, or it is relaxed by the government, and that person is promoted in his school day before yesterday.
Yeah, that is a subsequent development, we are not bothered. But fact remains that when as per the division bench order is correct, so that when the department is proceeding is pending against you,
Yes, I have submitted
Against
the
you.
reply. They have not proceeded further.
can't help it.
That they have not done it. Additional court has also in the paragraph 16, page 47 has stated by Lord, in the event if they fail to complete the departmental proceeding within 2 months.
No, that's almost the same order by the single bench.
Same court.
Division bench has considered.
Recently it is passed.
Can
He is the respondent, my lord.
But my 2 months has expired, my lord, long back.
it's over. You are no longer.
I'm
You are no longer holding.
I'm academic chair. Academic is only for looking after. Principal is the inspector of schools, is the IS. IS is acting as the in charge of the school.
Hmm?
Inspector of schools, Sunitpur, my lord, is the officially acting as in charge principal of the school.
Hmm.
And I am just only for looking after, because inspector of schools cannot come daily in the school. So I am just only for looking after, as I am the senior most teacher in the school. That is the thing.
But then department proceedings is again pending.
Pending.
Department IS is not doing, my lord. I cannot compel him to do, my lord. He is the employer, I am the employee.
Yeah, we understand. But then at the same time, when it is pending, normally it should be any promotion. In fact, for the regular promotion or what, it should be in the seal cover.
That is the law.
So if it is the law, what is your right?
I am not. He has given me the in charge,
It's
academic,
wrong.
not in charge, only for looking after.
Yes,
Only for
that
looking
is
after.
also
That is-
that would not also be permissible. You just write in, you have filed a caveat. Heard Mr. So-and-so in caveat, huh? Caveat is in the charge, huh? For caveat, huh? Heard Mr. So-and-so, learned concept of caveat, huh? Caveat is in the charge, huh? In writ petition, huh? Heard Mr. So-and-so, N. Bora,
At Bora.
learned counsel for the petitioner. Challenge made in this writ petition is to the order dated 11/12/2025, passed by the Inspector of School, Sonitpur District Circle, Tezpur, whereby whereby one Sri Abhijit Bora, assistant teacher of Tezpur Academy Higher Secondary School, Sonitpur, respondent number. Here, respondent number.
Yes, fine. 4 months.
Respondent number 4. Herein, huh? Has been allowed to look up to the academic affairs of Tezpur Academy Higher Secondary School, Sonitpur. List of. It is the case of the petitioner that since the departmental proceedings is pending against the respondent number 4, he would not have been allowed to look after the academic affairs of the school, which is an administrative post and also amounts to granting a promotion. And also amounts to granting the benefits of higher post. Stuff. Although this court in writ petition being WQC 4449 of 2023, passed by the respondent filed by the respondent number 4, has directed the respondent authorities to the effect that in the event the departmental proceedings is not completed, the authority shall appoint the petitioner as in charge principal of the said school in place of the petitioner hearing, comma, the division bench of this court. What is this? In a similarly circumstance matter has clearly has held that a person who is not exonerated of the charge in a department inquiry cannot be promoted as the as such person would not have any right to be appointed as in charge the principal of the headmaster list of
In charge academic principal, my lord.
the appointment and the impute order, although is by the impute order, although has been allowed the respondent number 4 to look after the academic affairs of the Tezpur Academy Higher Secondary School, comma, same would amount to a promotion in a higher post. Will issue notice, we'll consider it. Will issue notice returnable by 4 weeks as Mr. Tisti, SM Tisti, Learned Standing Council, Secondary Education, and Mr.
Be broadcast.
B. Prakash, Learned Council for Learned Council enters appearance, accept notice on behalf of all the respond. No formal notice need be sent. However, extra copies be signed. So, next paragraph. Considering that a division bench of this court in WPC. No, in the case of State of Assam versus Madhav Chandra Kalita, reported in 2026 SEC online, GAU, Gauhati 876, has already has clarified the has held that once the departmental proceedings is pending, the delegate officer of the employee cannot be allowed to be appointed as in charge principal or headmaster, headmaster, till the and considering that the issue, considering the issue raised in this present petition is similarly circumstance, I'm of the considered view that I'm of the view that an interim order is called for, this stuff. Accordingly, the appeal returnable debt, impugn order dated 11/12/2025, passed by the Inspector of Schools, Sonitpur District Circle, Dispur, whereby the respondent number 4 has been allowed to look up the academic affairs of Tezpur Academy Higher Secondary School, Sonitpur, shall remain suspended.
Much.
This after,
Much.
was it 3 weeks or 4 weeks? 4 weeks.
Much.
4 weeks. Immediately filed.
May I please, your lordship? Lordship, the
Just keep that. Division bench order there. Huh? Yes.
lordship, the matter pertains to be of earned leave benefits, earned leave benefit. And
Ah.
the instant petitioners are retired headmasters and assistant teachers of different ME schools of the elementary department. Lordship, the instant petitioners along with
Well, issue notice, we'll see.
Yes, ma'am.
Lordship, at this stage, if notice may not be issued as we are already retired and
The notice may be issued, we have to verify.
and
And
they
we'll
had
dis-
earlier, they had
Then
earlier.
we'll dismiss. If you don't want us to issue notice,
Lordship,
we'll dismiss the writ petition.
Lordship, if I may, Lordship, the instant petitioners has earlier approached this honorable court. But in
Why you
the,
have not been considered?
because in the earlier writ petition,
How many petitioners?
Three, my lord.
3.
in this petition, 3.
You were 8 petitioners.
8
in
petitioners.
earlier round of writ petition.
Yes, your lordship.
And what about 5 others?
They were from the secondary education department.
Okay, so why you have not been considered?
Because in the
You are
earlier.
not entitled.
No, your lordship. In the earlier writ petition, the order was directed to submit our representations to the respondent number 3 of the earlier writ petition, which was the secondary education department.
Ah,
We belong to the elementary education department,
okay.
for which we were not considered.
Okay,
Now
the commission authority of the secondary education has no jurisdiction to consider your case.
Yes, your lordship.
Yes, madam?
My lord, notice may be issued,
Huh?
my lord. Notice may be issued.
No,
my lord.
already matter has been settled. Only thing that anything is the authority who has to consider.
Then why they have not filed an interlocutory application? my
Huh?
lord?
For modification.
Yes, my lord. They have to file IA, my lord, in that matter, my lord.
I think
So
this may
kindly
be
matter
correct.
may-
Lordship, it's a squarely covered case. And
It's all right. Where is the direction?
Lordship, at page 33.
No, no,
Ah,
what
the
about-
respond before the are the retired headmaster of various schools, high schools, high school. Are you from high school?
Elementary school, ME.
No, that's why I said the before this court are the retired headmasters of various high schools. High school is a elementary. No,
No.
and they are praying for direction to the respond pay the earned leave and encashment benefits to your maximum. Yes, after the inconsideration, you have done a mistake.
Yeah. Inadvertently, your lordship, elementary was not.
So it has to be reviewed. It is to be modified. It's your fault. How can you blame? You file IA. We'll consider. Only problem is that since you are from elementary education,
Yes, sir.
the authority, who is this director of secondary education, individual representation assumed within. Director is not the respondent. Who is respondent number 3 here?
Respondent number 3 is the lordship, director of school.
Yes.
There is no concept of director of school education, my lord. In the director level, separate director. is
Director
there,
of
my lord.
secondary education.
Yeah, yes, my lord. Director
Ah.
secondary, director elementary.
There is no secondary education. There is a separate director. He is from school education.
There is nothing put like
Concept.
director of school education, Lordship. It should have
Okay.
been either director of elementary education or director of secondary education. Both are separate entities, Lordship.
No, that's what I'm saying. This is for director. There is a separate director for.
For elementary.
He is
As
from
well.
elementary.
Yes,
Yes.
Lordship. Lordship,
It's only that-
respondent number 4, Director of Elementary Education.
Then you have not said so. Hmm?
Lordship, kindly may I?
Who is respondent number 4?
Lordship, respondent number 4, Director of Elementary,
Where?
here in this writ petition. Your
No,
Lordship.
he's not in here. We're saying that in the earlier writ
In
petition.
earlier writ petition, inadvertently, we did not make a party to the elementary education, Your Lordship. That's why we are here with a fresh writ petition, Your Lordship. Only my simple prayer, Your Lordship, we allow us to submit a representation before respondent number 4, Your Lordship. We'll file our individual representations, Your Lordship. Representation.
Department check করবো লাগবে।
Okay.
मतलब notice में भी।
Huh?
मतलब notice में।
No, no, it's nothing. We'll allow them to file their representation. We'll allow them to file a representation. We're not saying that you should provide. Huh? Shall consider and pass reason order therein accordance with the settled position of law so and so.
যদি elementary party না হয়।
Same order will pass.
Lordship.
What is the outcome? Have they been?
The others, they have.
Others, they have been granted.
Considered. Their representations have been.
Simply what allow him to file the representation before respondent number 4. All right. Heard Mr.
P. Maria, Lordship.
Learned counsel for the petitioners. And also heard MS.
And focus.
Learned standing counsel,
Elementary.
elementary education. Next para. Considering the limited prayer made in this writ petition and as agreed to by learned counsel for the parties, this writ petition is disposed of at the motion stage itself. Huh? Please stop. Next para. The petitioners, 3 numbers are the retired headmasters and assistant teachers of various ME schools.
ME schools, Your
ME school in the district of Dhubri
and South
South.
Samara, Mankacha.
No, not various. Huh? The petitioners, comma. 3 numbers are the retired headmasters and assistant teacher of ME schools in the district of Dhubri and South Salmara, Mankacher. Mr. The petitioners along with 5 others had approached this court by filing a writ petition being WPC 2038 of 2025. Seeking a direction to the respondent authorities to pay earned leave encashment benefits to the petitioner for a maximum period of 300 days by calculating 30 days per year after deducting the period of leave encashment benefit already paid to the petitioner is paid to the employees of the non-vacation department. List of next para. This court. By an order dated 11/04/2025, dispose of the said writ petition. With a direction to the petitioner to file individual representation before the respondent number 3 and before the Director of Secondary Education, Government of Assam within a period of 1 month from today, within a period of 1 month from the date of the order raising their grievances. Thereafter, the Director of Secondary Education shall consider the representation and pass a reason order in accordance with the settled position of law within a period of 2 months from the date of receipt of the said representation. This next paragraph. It is the contention of the land counsel for the petitioner that the case of the other 5 retired and assistant teachers of the secondary education have been considered. Mr. Howard, since the direction was to the Director of Secondary Education and not to the Director of Elementary Education, the respondent director, the authority, particularly Director of Secondary Education, having no jurisdiction to consider the case of the petitioner, has refused to consider. Therefore, it is submitted that similar order may be passed to the Director of Elementary Education by allowing the petitioner to file individual representation. By raising their grievances. Next paragraph. Having considered that the case of the petitioner having been not considered only on the ground that the Director of School Education has no authority and jurisdiction to consider the case of the petitioner. As as it is the Director of Elementary Education would be competent to consider the grievance of the petitioner. And inadvertently, the petitioners herein have not sought for a direction to the Director of Elementary Education. And as agreed to by learned counsel for the parties, I deem it appropriate to dispose of this writ petition with a direction to the petitioners to file individual representations before the Director of Secondary Education, Elementary Education, don't make sense. Before this Director Elementary Education, Government of Assam, within a period of 1 month from today, and on receipt of such representation, the Director Elementary Education shall consider the case of the petition, consider the representation, and pass the reason order in accordance with the law within 2 months from the date of receipt of the representation, individual representation filed by the petitioner. The petitions disposed of.
Much obliged.
In this instance, disposed with the above direction.
Item 6. May I please, your lordship?
Yes,
Lordship, I have challenged the order of suspension. That is at Annexure 1, page 20. It is issued by the Governor of Assam on dated 10/2/2026. The allegations against me,
Page
Lordship, it is at page 20, Annexure 1.
20?
20.
20.
Yes.
Yes.
Whereas I'm reading from the second para. Whereas the inquiry has entirely revealed that the allegations made by the students of SNJ Homeopathic College regarding the sitting in the subject of Merita Medica in the third BHMS examination are substantiated in as much as the students were found bringing answer sheet containing the response exactly matching the question set in the Merita Medica question paper, raised serious doubt about the integrity of Dr. Manoj Kumar Deka, that is the petitioner, who was functioning as the head of the department Merita Medica during that period. That is the first allegation. Lordship, at that point of time, the question setter was someone different, and I was only the head. And in the question, the entire
That
examination
will be considered during the course of departmental inquiry.
Lordship, then second question, everything I was placed under suspension on the strength of some false allegations. Lordship, the second one is, I was neither the head at that point of time, nor I was the question setter. That is the first. The second allegation was that,
All these are the methods.
Lordship, I will show that the second allegation, which was brought against me, was done by something else, and I was put up with blame.
This is a matter of to be in the departmental process, considered in
Lordship,
departmental
because the
proceedings.
suspension was done.
Have you not been
arbitrarily and illegally,
given-
that is why I have challenged the suspension.
No, how can we interfere
Lordship,
with
once the suspension is illegal or in
What is
arbitrary
illegality
exercise-
here? We
because
don't
arbitrary-
know.
Lordship, I
Until
also,
the time the departmental proceedings is concluded, how do we know that it's illegal?
Lordship, I will show with the documents annexed with the read petition that the second one,
At best, we'll issue notice.
Lordship,
What is what is the status of proceedings?
no departmental proceeding has been drawn till now.
Huh?
Till that, no departmental
Then
proceeding has
you
been drawn.
approach differently. You, by filing this writ petition, you just trying to say that no suspension can be, no
No,
order,
when
order
the
of suspension
suspension
can be
and-
passed against you.
No, that is not, I am saying, because the suspension is
Therefore,
not a penalty, so it
you
can
have
be
not
passed.
committed any illegality or
Yes,
any
Lord,
wrong.
that is why I have not
So
committed
that
any.
we cannot
illegality.
consider it by this writ petition.
Because Lordship, the document shows that I have, the somebody has the second allegation, Lordship. Lordship, kindly bear with me for a moment. The second allegation is that
Sir, at best will issue notice.
if
Nothing
then
else,
short
nothing
date may be
else.
given,
Huh?
let them, a short date may be given, let
See,
them take instruction.
you are
If I
trying
have, my allegations are what
You are-
I have
You are
stated.
trying to that you are free from, I mean, you have not done anything, all allegations are false, therefore no suspension can be
No, Lordship, once the
You cannot
suspension
be
is given
suspended.
arbitrarily, then court can interfere.
arbitrary.
Because Lordship, the second one, the
See,
second
these
is-
are allegations. You'll be given an opportunity to
Lordship,
prove
document
it
shows
wrong.
that I have not permitted the second one. Lordship, kindly bear with me for the second one, second allegation, what they have stated. The permitted to student in the fourth BSMS examination without passing the third BSMS examination. Lordship, the document shows that it was given by the principal, not by me, who has allowed them to participate by notification.
The second may not sustain, the first will sustain.
No, first will also not sustain because
Obviously,
I was neither the-
obviously you will say so.
no, I was not the head of the department. And third one,
Okay,
That-
we'll issue notice, that's all. I'm not impressed.
maybe.
You may have a different pleadings challenging the suspension. I will not make you, I'm not trying to make you wise
No, I know
or
that.
wiser. Try to understand, think about it, not this form of petition.
Because Lordship, here,
In this form, will not be able to, I mean, grant any relief.
no,
Think about it. We'll just issue notice. Heard, Mr.
SN Tamuli.
S.N. Tamuli, learned counsel for the petitioner. Challenge made in this writ petition is to the order of suspension passed by the Commissioner Secretary to the Government of Assam, Medical Education and Research Department, page 22. Dated suspension order dated 10/2/2026. Issued by the Commissioner and Secretary, page 22. Whereby the petitioner is placed under suspension by exercising the power under Rule 6 within bracket 1 bracket close within bracket small bracket close of Assam service within bracket, discipline and appeal bracket close rules 1964. Pending disciplinary proceedings. List of. Next para, issue notice returnable by 4 weeks, 3 weeks.
Short date, maybe 2 weeks because.
MS. Libora, learned council, learned standing council. For all, health and family welfare.
For all the respondents.
Department enters appearance and accept notice on behalf of all the respondents. No formal notice needed, however, accept copies so and so, so and so, so and so.
Disciplinary proceeding has not been drawn yet, pending drawal of disciplinary proceeding.
We'll go by what is there in the contemplating departmental proceedings. Or, yes, pending drawal of departmental proceedings.
Method.
Milord, item 7 is the read petition, Milord. There's the fresh read petition. Actually, this is the third round of read petition, Milord. Initially, Milord, the petitioner was principal of Assam Engineering College, Milord, Gauhati, Milord. Milord, in May 2023, there was an incident, Milord, where unfortunately, Milord, 7 students, young students of the college, Milord, expired in a road accident, Milord. And immediately thereafter, Milord, this gentleman was asked to go into compulsory leave from 1st of June 2023. From that date, Milord, till date, Milord, he has not been allowed to join back, Milord. The compulsory leave was set aside by this court at the first round of litigation. Subsequently, Milord, he was suspended. That was also set aside, Milord. There is a direction that you reinstate him, complete the 2 disciplinary proceedings within 3 months, Milord. They have violated that order, Milord. They have concluded only 1, and there, which I am challenging now, Milord, that disciplinary authority finding, Milord, they have reduced my rank to a professor and posted me in Dhemaji, Milord. So that is the impugned order before your lordship.
Well, issue notice.
Milord, I am asking for a stay, Milord. Why am I asking for a stay, Milord? And what they have done in the meantime, Milord, they have also advertised the post. The recruitment for that post is going on, Milord. Milord, why I am asking, Milord, is completely perverse, Milord, on the very face of it. Lordship may take up this list of date, Milord. Very quickly, Milord, I will show you this is the 3rd round, Milord. Continuously, one after another.
They've issued the advertisement.
They have issued the advertisement. The recruitment interview has taken place. Yes, in the same post, Milord. That needs to be stayed, Milord. Because kindly have this, Milord. This has a history, Milord. That's why I'm pressing this, Milord.
Later, Mason will not say anything.
Serial number 4, Milord, of this. Quickly, Milord, very quickly, Milord. Serial number 4 is that incident, Milord. Serial number 7, Milord. Milord, he was asked to go on leave. Now, a discrete inquiry was constituted, Milord. Next page, serial number 12. The first show cause was issued, Milord, the first disciplinary proceedings, which is not yet concluded by them. Now, Milord, I challenge this, that my compulsory retirement. Your Lordship has heard it, Milord. Serial number 15 and serial number 16, Milord. Your Lordship has set aside that order, Milord. And what they do, Milord, immediately, based on 2017 recruitments, Milord, they suspend me in 2024. Based off a recruitment process of 11 polytechnics and engineering college in 2017 that took place, January to April. They suspend me in 2024 and initiate a 2nd round of disciplinary proceedings, serial number 20, Milord. So I challenge that suspension, Milord. So this court again, Milord, set aside that suspension. Set aside that suspension and directs, with that direction, Lordship may come to now straight away, Milord. The impugned judgment, the judgment is at page 64, Annexure 8.
So ultimately, it has been culminated into a departmental proceedings.
Yes, Milord.
And by this impugned order, you have been, certain penalty has been imposed.
Milord, yes, Milord. That's what I'm saying, Milord. What are the charges, Milord? I will just show, Milord. What are the charges?
No, we'll consider all these things, sir.
Milord,
Today we cannot
Milord,
do
the
anything.
proceedings which they have initiated, Milord, that is an
Demotion or promotion of professor upon the petition.
Milord, that is
Consider
annexure.
how the departmental proceedings has been.
Milord, it is totally perverse, Milord, because the inquiry officer also is saying, Milord, not proved, partially proved, only 1 charge out of 5.
That will consider, sir.
Milord,
Consider,
therefore,
we issue notice today, it needs the deliberation
Milord,
on the issues.
so therefore, Milord, one request, Milord, Lordship, he is retiring next year. He has not been allowed to join back as a, now he has been sent to Dhemaji as a,
Now, obviously, when you have not the same post, you cannot be.
No,
When
no,
the
I am not-
penalty is
I
involved.
appreciate that. I appreciate that.
Demoted.
Milord. What I'm
Where's
saying,
the impugn order, sir?
Milord, in impugn order,
We'll consider everything.
Annexure A1 is the impugn order, page 44.
44.
And Milord, I am also Annexure 14, Milord. I'm drawing your Lordship attention to Annexure 14, page
First,
144.
see the page, the impugn order.
44, Milord.
44.
Yes.
Yes.
So, Milord, here your Lordship will see page 44 is the narration of facts, and page 45 is finally, Milord, last 3 lines, Milord.
The governor is pleased to impose the penalty of demotion to next lower level of post, that is
Yes,
to the
sir.
post of professor.
Yes.
You were?
I was principal of the Assam Engineering College, Gauhati.
Okay.
Now I have been reduced to the professor, Milord. And Milord, page 141, Milord, is the consequential order by which, page 141. This is also I've challenged. I have been posted
141. Yes.
So it says on reinstatement in service,
Is
Dr.
hereby
Atul post
registered in
professor.
service.
So he's been sent there.
The Atul Posters Professor in Engineering College with immediate effect. Obviously.
So therefore, next page, Milord, 142. This is what I am saying, Milord. This has to be stayed, Milord. The 142, they have advertised for the post of a principal assessor. This is the post, Milord. So this process, this cannot go on, Milord. This has to be stalled because this is the third round, Milord. From 2023, I was kept out of the post.
No, ultimately, all this has been culminated in the final proceedings.
Totally
and then,
perverse, Milord.
wrongly or rightly, certain, penalty has been imposed against you.
Right, Milord?
Right.
Totally perverse, Milord. Totally
Whether
perverse.
this is perverse or not, we'll consider.
Milord, therefore, this has to be stayed. Milord, I'm saying, only saying, this advertisement subsequent.
When you are going to retire?
Milord, otherwise, Milord.
When you are going to retire?
Next year, Milord.
Next year.
Next year.
All consequences, if you are writ petition and consequently you will get everything.
Milord, therefore, Milord.
We just cannot install the.
Milord, this, at least this should be subject to the outcome of the.
No, unless outcome, it's always there.
Yes, Milord. Milord,
Yes, go. Outcome, subject to outcome, it's always there. So we'll just say the outcome of the writ petition. Any appointment, any selection process in terms of the advertisements will be outcome of the writ petition. It's always there.
One ST candidate was not there, that's why ST post is vacant.
Ah.
Otherwise also, Lordship, this writ petition is not maintainable as because, Lordship, there is a statutory prescription is there, appeal provision is there, Lordship. They have no go for appeal, Lordship. As per section 16(2)(b), Lordship.
5 points.
Appeal provision is there, Lordship.
Yes. What under which rule?
16(2)(b).
Yeah.
1964 rules, Lordship.
Milord,
Statutory
5 on this, Milord, 5. First, Milord, that this is, Milord, an appellate authority is an executive authority, Milord. So therefore, my grounds are on violation of 311, Article 311, sub-article 2. That is first, Milord. That is first of the one grounds. Second, Milord, only because there is an appellate provision in the rules, that doesn't preclude your Lordship from.
That's your appeal.
Milord, third, Milord, most important. Who is the appellate authority, Milord? The same governor is the appellate authority. So therefore, the appeal will go before the governor who has passed the order, Milord. So therefore, the authority who has passed the order.
Then you challenge this provision.
Milord,
Until that time you challenge
Milord,
this.
it is and Milord, because Milord, the same authority cannot, because that's what I'm saying, because he is retiring next year, Milord.
No, so you have to challenge this provision.
Milord,
A government servant may
it cannot be
against
challenged
who's
because
denying
for others, Milord, for others, this is a valid provision because anybody in professor rank, it is a valid provision. Since I'm a principal, Milord, so therefore I cannot challenge it because it will go before the same authority.
Reverting a lower service, huh?
Yes, Milord.
Grade, this is lower service. Yes. 16(2)(b).
Actually, Milord, it is rule 14 of the disciplinary rules.
Huh?
Rule 14.
14.
Appellate provision. Huh? Milord, it will go before the same authority.
Appeals against the orders of suspension. No.
It's not it's a final order, Lordship.
Appeals against the order imposing penalty. 15. The government servant may appeal against the order imposing upon him any of the penalties specified in Rule 7 to appellate authority specified in this behalf in this schedule. There shall be no appeal against the orders of appellate authority. Huh? What is Rule 7?
That is, my lord, the
You
major
have been
punishment.
imposed on,
Major punishment,
huh?
major punishment. my lord.
Then, is it a major punishment?
Yes, lowering the rank, my lord, yes. My lord, and the same grounds were raised by. My lord, same grounds were raised by them in the earlier round of petition also, my lord. So that also was rejected, my lord, and the suspension order was set aside. So therefore, my lord, it is.
No, that
continu-
was suspension.
Yes, my lord. So therefore, my lord, it is continuation of the same proceedings, my lord. So therefore, my lord, going back to the same authority, because lordship has just seen Annexure 1, the.
Now
law.
presently we are not dealing with the final order.
Yes, my lord, therefore, my lord.
Final order of the
But the
penalty.
principle is the same, my lord, because even worse in this case, my lord, because the authority which has passed the order, the impugned order, my appeal will lie before the same authority, my lord. So I am not,
Cannot be the same authority.
it has to be the same authority. It is the governor. Because nobody else, highest authority has passed the order.
Who is the authority here?
Governor, my lord, because he is the highest authority. He has
From-
passed the impugned
From
order.
where you get it?
My lord, I have shown page 44, impugned order.
No. It's okay. It may be governor.
It's the name of the governor,
or
also,
what?
not by the governor. Also.
Huh?
The governor will not pass even the appellate order. It is always in the name of the governor. The executive function is exercised on behalf of the governor, my lord.
That's what I'm saying.
Yes,
You cannot
therefore, my
say
lord,
that this has
therefore,
been
my
in
lord, therefore, even worse, my lord, kindly have page 45.
No, sir.
My lord, the
This
same
is page
person.
44 is by the commissioner secretary in the
Yes,
name
so
of the
therefore,
governor.
therefore, my lord, you'll go before the same authority. my
Article
lord.
162 and 166. It's
Milo-
always in the name of the governor. It doesn't mean that if the order is passed in the name of the governor, huh? It doesn't mean that he cannot take up the matter.
My lord, as per the.
Appellate authority as a governor
Yes, my lord.
is one thing,
Yes.
but the passing an order by the authority in the name of the is quite another thing.
My lord, it
It's
has
in
been
view of
signed.
the Article 162 and 165, 66.
In the, your lordship is right. The executive function is exercised
So
in the
you
name of-
cannot say that this is by the governor. It is in the name of the governor.
in the name of the governor, my lord. But then here, my lord, finally the order was signed by
Hmm.
the Commissioner Secretary, Higher Education Department.
Yes.
So therefore, my lord, as per the rules, there is no specific officer, my lord,
Who is the disciplinary authority?
is Commissioner Secretary.
Then
It is
appellate
going-
authority is the governor. He'll exercise, but this order is by the disciplinary authority in the name of the governor. In view of the provision article constitution.
But in that case, my lord, in that case, my lord, because the governor in the second round also, my lord, in the
We'll
appeal-
issue notice
Yes.
and we'll keep the maintainability open. We'll hear you. Therefore, no order can be passed.
my lord, at
Interim
least-
order cannot be. We'll simply say that subject to outcome of the writ petition. Any appointment to the post of what? Principal of,
principal, yes,
is a specific principal, post is a specific college.
yeah, Assam Engineering
There
College.
is a 5 posters vacant. 4 posters already fill up. Due to the lack of ST candidate, Lossi, 1 posters not fill up, Lossi, it will go to the Dhemaji college. Otherwise, all the college post is fill up, Lossi. Here, Lossi, my lord may, if you see not.
Any appointment,
That part I have not get on, Lossi may keep the maintenance part open, Lossi.
that will keep it open. Interim will say subject to outcome. Any appointment,
No, that part I have not.
what is that principle of?
Ah.
Any appointment made in the post of principal of Assam Engineering
Engineering College,
College
Gauhati.
shall be subject to outcome. That's what we'll say simply.
Already appointed, Lossi.
We'll just
It is
simply say-
not before that particular advertisement, Lossi.
Yes.
Before that particular advertisement, he was appointed, Lossi. When he was shifted to the Lordship, Gist, Lordship.
Where is that advertisement?
Page number 142.
142.
Yes.
Post of principal
Yes.
in the state engineering. It's not only one. Number of posts 2. Principal Government Engineering College of Assam.
5 posts, Lordship. Two
But
is
those are-
unre-
Yes.
two is unreserved, Lordship.
two
One
posts.
for women reservation and one for.
Petitioner is unreserved.
You were principal of what?
Assam Engineering College, Gauhati.
No. He was not the principal of Assam Engineering College, Guwahati. He was transferred to the Gist, Lordship.
No,
Before suspension.
That has been set aside by
Yes,
your lordship, my lord. Those orders have been set aside. He never joined. In the meantime, he was suspended. So when he was suspended, my lord, he was principal Assam Engineering College.
Another problem is suppose the person who has been appointed
Yes.
to the post where you were serving is a party before this court.
We will
No.
implead him, my lord. We will, because lordship is saying.
Then we'll pass the order on that day. You implead them and we'll see.
My lord,
Because we'll not make it complicated, right? will not, I mean, trouble,
My lord, I'm not saying.
will
that-
not trouble third
Huh.
party without their fault.
My lord, I'm only saying, my lord, any consequence arising out of this advertisement, my lord, which is at page 142, my lord,
Hmm.
that may be subject to outcome of this writ petition, my lord. We are not saying any specific individual should be affected, my lord.
That
I'm
cannot
only
be
concerned about, I cannot say, my lord, only
They only
post of
cannot back
Gauhati.
one lawsuit.
His claim is to the post of principal, my lord. So therefore, my lord, outcome of this
Yes,
has to be
yes,
subject to
yes,
this.
yes.
I'm not saying about any specific individual. So that, to that extent, I don't think my friend will have any objection. He can't have any
My lord, may
objection.
kindly page the NB point. Only lordship, the ST plain candidate was lordship,
Unreserved, huh? Yes,
non-availability of the candidates
you
lordship.
are ST, no?
No, no,
No,
lordship.
unreserved, my lord. He's unreserved. I'm only saying to that extent, my lord, this
Yes,
process.
Her
should-
Mr. Rituras Biswas, learn counsel for the petitioner. Next para. Challenge made in this writ petition is to the order dated. What is the order?
My lord, an act of
22.
44, my lord.
22/01/2026 passed by the Commissioner and Secretary to the Government of Assam. What is higher?
Higher education, my lord.
Higher Education Department,
Education lordship within bracket technical lordship.
within bracket technical, higher education, within
doesn't
bracket
say so.
technical department. By which the petitioner has been imposed a penalty of demotion to next lower level of post in terms of Rule 7 within bracket small Roman, bracket close of Assam services within bracket discipline and appeal bracket close rules 1964. You get it from page 45, huh? The petitioner has also put to challenge the order dated 23/01/2026 by which the petitioner is posted as professor, civil engineering department, Demaji Engineering College on his reinstatement. List of issue notice returnable by 4 weeks as Mr. Next para. K. Gogoi, learned standing counsel,
120 lordship.
standing counsel,
Standing counsel, technical education department.
higher technical education department. And Mr. So. Huh? Standing counsel?
Yes.
Huh?
Yes. Assam Public Service Commission.
Entrance appearance to accept notice on behalf of all the respondents. No formal notice need be served. Only 4 respondents. Yes,
Yes, my lord, 4 respondents, yes.
need be served. However, extra copies be so and so, so and so, so and so. Huh? The issue of maintainability of the writ petition in the present form in view of the provision of Rule 16 within bracket 2 bracket close bracket within bracket small b bracket close, huh? Not the capital B, small b. And as raised by the Mr. K. Gover, same shall be considered on the next date, on the returnable date. Next period. Upon further consideration that the petitioner was working as principal of what?
Assam Engineering.
Assam Engineering College.
Gauhati.
before the impugn order. Until the impugn order. Impugn order. Demoting into the next lower level of post as professor, any appointment to the post of principal, Assam Engineering College shall be subject to outcome of this writ petition. Please, no, list of, since the interim order. No, it's okay. You do whatever. Simply say, we'll say any appointment made to the post of so-and-so. But one thing, you think about it, bring them those part, I mean, because they should not be allowed to suffer. Because they are not, they have no any, I mean, we cannot attribute any fault on them.
My lord, maintainability part.
I've recorded.
My lord, item 1, my lord,
List
because
after,
lordship may, with that,
list
this-
after 4 weeks.
my lord, the contempt has to be, that notice has to go, my lord, because page 100 of this paperwork only, my lord. The same
Mr.
paperwork,
So-and-so, learn counsel for the petitioner.
page
This
100
is an
is,
application under section 1112 of Contempt of Courts Act 1970, read with article 215 of the Constitution of India. And the Contempt of Court within bracket Gauhati High Court Rules 1977, alleging willful and deliberate violation of judgment and order dated 13-10-2025, passed in WPC 1547 of 2025. Next, for issue notice returnable by 4 weeks. The Lord Council put the petitions to take steps for service of notice upon this contempt by speed post as well as usual process within 3 working days. That's all. Yes.
Matter pertains to appointment of teachers in lower primary and upper primary school.
What, sir?
Lower primary and upper primary school, regarding appointment, my lord, basically my candidature has been rejected on the ground of I couldn't submit the NIS UDIS. So in that case, a similar case has been filed, and in that, my lord, would please to find the order at page 216, my lord.
UDIC code.
Yes,
Where is this now? You are challenging notification.
yes, my lord.
Where it is?
My lord, it is at page 170, my lord. 170,
170.
yes.
Yes.
My lord, this case has a very interesting history. Basically, in the year 2017, the right of children.
No,
to
no,
free-
let us see. Why you are challenging this?
Yes, yes, my lord.
For recruitment of regular teachers of LP and UP schools, that they need to submit the details of procedure and NIOS UDS for whom it is applicable. Then
So this UTIS was not mandatory for these petitioners, basically. This,
same thing, this page 171.
yes, it is the extension, same thing, my lord. It is the
Then-
extension of time limit, my lord.
So
So,
what's wrong here?
so the wrong is that I'm coming to that. My lord, very
Come to that.
directly, I couldn't come because
Directly, you come directly, no
Because-
time.
it's a history, my lord, because
Ah.
in the year 2017, so the Right of Children to Free and Compulsory Education Act was amended, the section 23, which mandated that by 31st of March 2019, the person who have not acquiring the minimum DLED qualification, basically diploma in elementary education, in service teachers in government aided and private schools, basically. So they will have to lose their jobs after 31st of March 2019. So then what happened? All over India, more than 14 lakhs teachers were there, though they were in service, but they didn't have that DLED qualification. Then government through NIOS, they made a, they have made this NIOS 18 months DLED course, my lord, because the DLED course is for 2 years. So it was reduced for 6 months and it was made for 18 months only. And these petitioners have done that 18 months DLED course. Thereafter, it was challenged before the Honorable Supreme Court. It went up to Honorable Supreme Court. Honorable Supreme Court has decided that on 10/8/2017, the person who were in service, then they will have to, that DLED, 18 months DLED, it's applicable for the fresh appointment also. That was declared, my lord. Thereafter, what happened? They have issued this notification saying that first you submit that you have the UDIS code as on 10/8/2017, then it is a proof of in service. So we are basically challenging that. That cannot be a proof of challenge, my lord, because that was not mandatory. In the year 2017, the UDIS for the in-service teachers was not mandatory for all schools. For this, we have challenged this. Otherwise, we didn't have any objection regarding submission of other documents relating for the in-service. We have the joining letters, we have the appointment letters, we have the experience letters, my lord.
According to you, since in 2017,
Yes,
this UDIC was not required.
yes.
It's a
That
new-
was not mandatory.
mandatory.
Yes.
It's a new creation after 2019.
Oh,
You-
it was
you-
earlier, it was there, but it
you
was not
cannot
for
be-
all school, my
You
lord.
couldn't be insisted, they cannot insist on you to submit this
Yes,
of the year 2017.
yes,
That is what you are saying.
yes, definitely.
You are in service.
Yes, we were in
teacher.
service. Yes.
Now, can it be, is there no provision that when you are serving, when this requirement of UDIC is created,
Yes.
can you not have that UDIC afterwards,
Afterward, that.
after being created?
My lord, we have, yes, we have UDIS
Huh.
after that.
Okay.
Yes, we have UDIS after that.
What you are saying that when it was not mandatory, which you have not done, which you have not, which you don't have, so you cannot be insisted to submit that.
My lord, yes. That is my prayer on that.
Well, on the same ground, lawsuit may get down to page 200. That was the earlier notification.
Hmm.
That was put to challenge. That was dismissed by this honorable court lawsuit, and it is under appeal. It is before honorable division bench lawsuit. The same subject matter has been.
Then we'll issue
Yeah.
notice, we'll see.
And this recruitment and this process, we have already completed the recruitment process lawsuit. Appointments have already been made.
Will not pass any interim.
My lord, my lord.
You are working still. You are working
I'm
still.
working in a private school, not in a government school.
Okay. Heard Mr.
BM recommended.
BM Deka, learned counsel for the petitioners.
Yes.
By filing this writ petition, the petitioners have put to challenge the notice dated 19/11/2025 and 27/11/2025
And
issued by the
And also 17/06/2025, my lord.
17.
06/2025.
Which was earlier put to challenge, that was dismissed.
Then you see, then you say, first one is,
First one is 19/11/2025, my lord.
then
27/11/2025
then
and 17/06/2025.
Which is the original notification.
that is earlier. That's why I'm
Yes.
asking.
Yes, yes.
First,
Correct.
Sorry, my lord. It's a-
let us be
the sequence-
chronological
sequence,
order.
yes,
Huh,
yes.
sequence.
The sequence should be 17/06/2025.
17/06/2025, 19/11/2025, and 27/11/2025. Issued by the notices, you just notices. As dated so and so, issued by so and Director Elementary Education, Assam. Whereby it is provided that all the candidates who have successfully submitted their online application against the Director of Elementary Education, pursuant to the advertisements for recruitment of regular teachers of LP and UP schools, are required to submit the details of SSLC examination and NIOS. What is this? National
National Institute of
Open
Open Schooling.
UDISC. Within bracket, for whom it is applicable. bracket close. Failing which the failing which same would lead to cancellation of the candidature. This stuff. Next para. It is the
Issued in terms of the Honorable Supreme Court direction lordship in Procedural versus.
I will not say anything since we are not staying, I mean, passing any interim order. It is the contention of the petitioners that the requirement of submitting UDISC
Yes.
is a recent origin, recent origin.
My lord, it was originated in the year 2009, I think, 12. Yes, from 2009, but it was not mandatory for all school.
No, since the, no, it is the contention of the petitioners that when the requirement of UDISC was not mandatory
Yes,
till 2019,
as on 2017.
as on 2017, and the petitioners having been completed their degree.
Yes.
What is this?
Diploma in elementary education.
Having been completed 18 months diploma in elementary education from National Institute of Open School, the requirement of submission of NOIS-UDISC by the authorities would deprive the petitioners from participating in the recruitment of teachers of LP and UP schools.
Yes.
List up. Next para. Issue notice returnable by 4 weeks. As Mr. SMTC Learned Standing Council enters appearance and accepts notice on behalf of respondent 1, 2, and 3. No formal notice need be served. Extra copies. Petitioners to take steps for service of notice upon respondent 4 and 5
My
by
lord.
speed post as well as usual process within 3 working days.
My lord, in a similar matter, notice has been issued. That may be tagged with, my lord.
We have also issued notice.
My lord,
What's the matter along with
WBC 842 of 2026.
8-4?
842.
When it was issued, notice was issued,
My lord, it is on 18 February 2026.
18 February, March.
Same issue, my lord. Same party, same advertisement. Much obliged, my lord.
842.
Yes. 2026.
842 of 2026.
Yes. Much obliged.
May it please, your lordship. Yes, the petitioners are the wives of the person who has died, your lordship, and they had not received compassionate family pension as well as the regular family pension, your lordship.
Oh.
He died on 3.
But Mr. Will issue notice,
Yes,
let
yes.
us see what's happening. The T. Dury Learned Council for the how many petitioners?
2, your lordship. They are the first wife and the second wife. of the person.
Petitioners. Next, this petition is instituted by the petitioner being the first and second wife of late Abid Ali, seeking a direction for payment of what? Payment of what?
The compassionate family pension as well as the
Compassionate
regular
family pension
as well as the other pensionary benefits.
and other pensionary benefits on account of the in respect of their in respect of their husband.
Yes, your lord. Dear husband. Definitely.
It's good. who had that while,
Pre
while,
2023.
while working as what?
Assistant teacher, your lordship.
Assistant teacher. In the what?
Assistant teacher, Kowarpur, Dokhin Singra, Ansolik High School, Hazu.
Where do you get it?
Your page 7, your lordship.
Assistant teacher at Kowarpur,
Yes.
K-O-W-A-R-P-U-R, Dakshin Singra Ansolik High School, Hajo, in the district of Kamruf, issue notice returnable by 4 weeks. As Mr. SM60 Land Council enters appearance on by responding 1, 2 and 4. No formations need to be served. However, extra copies says. Huh?
For respondent number
3. Then you write SM60 and Mr. So enter the appearance of Yahoo. Except notice on all the respondent, no formal notice. However, extra copies be served.
Yes, your lordship. I'm very grateful, your lordship.
Why? They should be in my Bible. 64. Yes.
In this case, the petitioner of the lordship is surrendering the influence transfer order at page 45, my lord.
What's wrong?
My lord, he has challenged this order, my lord, on 3 grounds, my lord. Basically, my lord, he is going to retire from his service, my lord, on attaining the age of superannuation on 28/2/2027. That is less than 1 year. This is one ground. Another ground, my lord, earlier also he was transferred. In that case, my lord, a status quo order was passed by the Honorable Court.
Who are you? What is your post?
I am the inspector of schools, Sirang, my lord. Serial number 2, my lord.
Is it a similar post?
My lord, many officers has been transferred along with in this order, my lord. I am at serial number 2, my lord. 30A.
Page
45.
Page 46, 45, my lord.
45,
My lord.
Serial number?
Serial number 30A, my lord.
In the interest of public city, Vijay Vaishnav. AES means what?
Assam Education Service, my lord.
Inspector of Schools and District Elementary Education Officer. Chirang is a transfer and posted at District Elementary Dubri. What's wrong here? You have been posted as the same District Elementary Education Officer.
My lord, I am retiring in the month of, my lord, February 2027.
Where it
Less
is?
than 1 year, my lord.
You cannot be transferred.
My lord.
Where it is?
My lord, I am reject.
There are judgments to that effect.
Not judgment.
Judgment, sir.
Under which law?
My lord,
What is the rule?
there is no such rule.
If there is no rule, we'll consider on this.
My lord, that
Let's
is
submit.
another.
The code of conduct has been operational since yesterday. Nothing is going to work out. And he has not stated anything as regards the status of his transfer order. Whether he is released, whether he is
No,
in
I
patient,
have
nothing has
not-
been stated.
I have not.
So
been
status
released, my lord.
quo, as on today, our lordship may be pleased to issue notice, my lord.
Already a status quo order is operating in my favor, my lord.
Only for 3 weeks, your lordship.
That was,
There are judgments, it would automatically get vacated, your lordship. Your lordship is aware of.
and
Limited period for committee basis. Release course नहीं
my. Yes. আগতে BTC রিলিজ করিব লাগিব তার সাথে যাব পারিব।
ये तो हमको लिखा नहीं है, status तो लिखा है, status तो लिखा है।
Paragraph 13, actually, paragraph 13 to subsection.
Paragraph 13.
Yes, then.
What is the instruction here in your case?
My lord.
Where is the government office member or any instruction where it is?
My lord, another aspect, my lord, my wife is.
I am asking something, where it is? This case was Agartala case, there is a government
My
instruction.
lord, basing on that, my lord, another
And
case.
other one, this is Kabul Chandra Saikia.
Yes, my lord.
Where this is on what basis?
Another order I have also annexed in the petition, my lord. Page 37. In-
And this was for 5 to 6 months. On its own facts, it was considered. No, you show us any instruction of the government where you should not be transferred within I mean, 1 year
My lord,
from the date of your retirement.
there is nothing such.
Then
Instruction, my lord.
these were all on the
But-
facts and agreed by the, and if she agrees, we'll stay.
My lord, my friend is.
If she agrees, we'll stay.
My friend is agreeable on the status quo, my lord.
Agreeable in the sense, since the code of conduct
See,
is
what is it?
operational.
You are, this one case too, there's a government instruction. Normally, within 1 year of retirement,
My lord.
should not be, because it may, I mean, create some problem
Yes,
for the retiring employee.
My lord.
I don't know, Assam should have
Assam also
should have
follows
that
the same-
instruction.
My lord,
It
those,
is you should,
they also follow the same, my lord. Assam also
From
follow
where?
the same, my lord. In the, my lord, I have also annexed one order at page 37, my lord.
forget the order. I
Also
want,
Assam
I
government-
want
Assam
the
government
instruction,
employee, my lord.
instruction of the government.
No such,
Huh?
no such instruction. I
There's
found.
no office memorandum, no circular,
I
nothing.
did not find, my lord.
Huh?
Maybe, my lord, I did not
Pele
find.
you, then first you find it out.
My lord,
Otherwise, you are not inclined. We'll dismiss the writ petition.
my lord, another ground I have taken, my lord. There is an office memorandum of this, the state of Assam, that the spouses should be, my lord, placed at the same station.
It's not
My wife,
mandatory.
my wife is working at Kokrajhar, and I am, my lord, at Chirang, my lord.
Huh.
If I am to be transferred, my lord, I should be transferred to Kokrajhar
Then-
or,
It's not mandatory. It's not a statutory rules.
my lord, interpreting that order, my lord, that office memorandum, my lord, this honorable court has also decided many cases, my lord.
The cases are decided, judgment or decisions are taken on the, first on the facts and circumstances of particular case, on the contextual facts only. You cannot bring everything
My lord,
together.
that office memorandum has been decided by this honorable court at page 28, my lord. This is the decision of this honorable court, my lord, wherein this honorable court held that, my lord, the spouses should be placed at the same station
Hmm.
in terms of that office memorandum.
His spouse hasn't come. before
Normally, as far as practicable. See, there is a Supreme Court judgment also. Same station, spouses.
My lord.
It's not mandatory. It's not a statutory rule.
My lord, at the verge
At
of
least
the
have
third,
you
my
have
lord.
that instruction of within 1 year and all that we
I am
could
at
have
the verge of-
considered.
My lord, I will.
You yourself saying that there is no instruction of
I
the
did not
state.
find- I do not say that there is no such, my lord. I
Heard
did not
Mr.
find-
I.S. Chakia, learned counsel for the petitioner dismissing.
No, my lord, Shuma kindly.
You are not able to
My lord, that-
place anything by filing this writ
Lordship-
petition.
Lordship will
The
take up the matter, my lord, on Friday, my lord,
petitioner-
in that case, my lord.
has put to challenge the common transparent order, transparent posting order issued by the Commissioner and Secretary to the Government of Assam, Department of School Education, whereby as many as how many persons?
Well, my lord.
As many as 12 officers,
In my
have-
post, one has been
officers,
posted.
including the petitioner, has been transferred. What is the order date, na? Sorry, order date 12/3/2026, huh? Transfer and posting order dated. This is 11/3,
11/3, my lord.
11/3/2026, passed by the Commissioner so and so, huh? Commissioner and Secretary to Government of Assam, Department of School Education, whereby as many as 12 officers have been, officers including the petitioner, have been transferred to different places of posting. Huh? it is the contention of the petitioner that the petitioner would be retiring
Retiring on 28 to 2027.
28 to 2027. And the petitioner, where is the petitioner is sought to be transferred within 1 year of the 1 year of his
Less
retirement.
than 1 year, my lord.
List of on pointed query, Mr. Sekya, land counsel for the petitioner, submits that he has no, as regards any circular or government instruction. No, is not pointed query as regards the circular oblique government instruction transferring the employees oblique officers, employees within 1 year from the retirement. Come on, Mr. So-and-so, I say, land counsel for the petitioner. Submits that he has no knowledge as regards such circular or instruction. Mr. However, considering that the petitioner is sought to be transferred from, is sought to, however, considering that the petitioner appears to have been transferred within a period of 1 year from his retirement. Let notice be issued, returnable by 4 weeks. And MS.
Five for B2C, my lord.
MS so-and-so.
I am for 1 and 2, lord.
And then SMT 60 and Miss MS so-and-so, land counsel appearing on behalf of MS B. Boya, land senior counsel. Enters appearance and accept notice on behalf of all the respondents. All the respondents, both of you. No formal notice now, but extra copy, so-and-so. You furnish the extra copy. You have not been released.
I have not been released.
She said, once this, what is called? Model code of conduct has come into play, you are saved.
My lord, lordship,
Don't-
observe
yes.
that minister has come maintained as on today, my lord.
See, sir, I have given you enough opportunity to place something.
My lord, in the last order, my
There
lord,
must be some basis, must to cling on.
my lord, last order, my lord, lordship, was observed on the opinion, my lord, no coercive action should be taken against the petitioner. At least that must maybe, my lord,
What coercive?
my lord, in the meantime, they may.
See, when your employee is legally transferred, if you are released, other than release from that particular place, cannot be coercive action.
No, at least give a observation, my lord, at least. My lord, the status quo may be maintained, my lord. Status quo as on today.
Status quo in sometimes creates a havoc.
Lordship, my lord, as I have not been released till today, my lord. And
He
I'm
has not
talking-
stated as such in his
I have
petition.
in paragraph 13, I have stated.
May be released at any point of time. At the time of filing of the writ, that is a statement.
I have not been released, my lord, till today, my lord.
Since the model code of conduct has come into effect, the consequences would follow.
Of license.
We're indicating,
Lordship, observed, my lord. Lordship, observed, my lord.
that's all. I have observed that.
But status quo may be observed, my lord.
Thank you.
My lord.
Lordship, with sincere apology, Lordship, can I seek for 10 days further time to file my additional affidavit as per the last order, Lordship? After 10 days, Lordship, a date may be fixed, Lordship. I will, Lordship, file, Lordship.
This is on 13/5. Oh, no, this is made out on
What is
February.
the matter? What is the matter about?
My lord, this is the initially, the petitioners, my lord, he was allowed to draw the 3 advance increment on obtaining
I think
PhD.
in that case, instruction will be required.
But the
It
finance
appears to
department,
be a little complicated.
but finance department, my lord, it is clear.
Huh?
Finance department has cleared the situation, my lord.
Then
Now on that, my lord, they are going to file additional affidavit.
finance has already cleared.
My lord, it is my favor.
Huh?
It is my favor.
So they want to oppose that.
By filing an
You
additional.
want to oppose that?
Yes, Lordship.
How can you oppose the finance department?
Lordship is perhaps not relevant in the present case, Lordship. So, Lordship, to that effect, Lordship, I will just.
Okay, I heard Mr. P. Mahanta, learned counsel for the petitioner. On the prayer of Mr. D. Upamani, learned standing counsel, higher education department. Further 3 weeks time is granted to file affidavit. 2 weeks.
Well, a small.
2 weeks.
Small prayer, my lord. The matter is, my lord, lingering since long. It's a very small issue, and my lord, petitioner is suffering because he's going to at the version of
And
retirement.
rivers shall be
So, my lord,
to dispose of the matter on the next date.
that the date may be fixed, my lord.
Huh?
Date may be fixed.
Then 3 weeks. After 3 weeks, give the date.
Date. Before. And so that I can get a good result, my lord. 1 second.
Yes. Step into discover. Do something, it looks like we're not in the high court. Yes.
Mr. D.P. Bara, the conducting counsel of health department is on Lake's Lordship. Otherwise, he has received instruction, he has instructed me to place this before this honorable court.
What instruction? What is the matter, sir? Tell us.
Petitioner has retired from service as a principal of Silchar Dental College
Hmm.
in the year 2020. Departmental proceeding was initiated against him on the ground that Lordship petitioner, while as a principal of regional college Gauhati, he has taken money for the college authority for the dental graduate who want to internship from other dental colleges. As well as Lordship petitioner has.
Very serious charges. Huh?
One time like only.
Oh, there. You're seeking what?
I am seeking for release of the pension, regular pension, as well as the gratuity and the leave encashment benefit.
Area salary for an amount. For the period and so, sales in connection with contempt case. It's a contempt case or what?
No.
Apurva Kumar.
Adhyapak.
This is respect to A.K. Deshmukh. There.
No, my lord.
This is A.K. Deshmukh.
It should be A.K. Adhyapak.
No.
Wrong, Lordship, wrongly it was.
Wrongly placed. It is not the copy, my lord. I'm
Huh?
sorry, my lord. It is not the copy, my lord. My lord, but otherwise, the fact is that we need some time, my lord. Because, my lord, for imposition of penalty, my lord, the file has been moved to the APSC for approval, my lord, Assam Public Service Commission.
Are you challenging the imposition of penalty or what?
Lordship, because
We should release the regular pension as well as other pension benefit. As to why to pay interest on them. Legal intern.
Penalty is already imposed, page 104.
Then,
Penalty has been imposed. Lordship, therefore, Government of Assam Health Family Welfare Department imposed penalty of reduction to a lower service grade or post to a lower time scale or lower stage of time scale.
not dismissal,
Page 104.
reduction.
Reduction.
Of pay scale. So you are not claiming anything on that. You says that whatever you are entitled, it should be released.
Should be released. I have already preferred appeal against the order of imposing penalty that is pending before the authority. Appeal is
Okay.
filed.
So
Lord,
what
you
is,
kindly see initial order page 18 to 2026. This honorable court 18 to 2026.
15.phc होगा ना? 15.phc.
by whom?
So this is the instruction, the last one wrongly placed, my lord. This is AK Adhyapok, my lord. The other one, AK Desmukh, the other one was.
Proposed penalty will be inflicted on so and so. Is yet to be inflicted or what?
Penalty has been already imposed, reduction in rank, and review of penalty can be made after within 1 year from the date of imposing penalty. Now, Lordship, in 2022, penalty has been imposed. Now they want to say they want to review the penalty.
And for that purpose, the approval of the Assam Public Service Commission is required. So the file has been moved to the
Review what? Review of what?
Imposing
of the penalty, my lord.
After reviewing the views from Assam Public Service, it is a requirement.
Yes, my lord. It is the requirement to obtain
Of the role.
approval from the Assam Public Service.
So until that is done,
Yes, my lord.
it has not attained finality.
Yes, my lord. Yes, my lord.
When the proposal was made, proposed penalty was passed on 29-3.
My lord, that is not here, my lord.
29-3-2022. Have you annexed that order? Have you annexed that order?
Lordship will find at page 104, 11 portion, and
104.
it start from 101.
Now therefore government in so and so reduction and lower grade so. Of course, this has been issued in way back in 29 March 2022. So still you have not completed the process.
How they can do, Lordship? Already a penalty has been imposed after consultation of the APC. I have preferred appeal before the governor, and appeal is pending. And now I want regular pension as well as the benefit.
Whatever you are entitled after
Lordship.
imposing of the penalty,
Lordship,
after reduction,
after reduction.
whatever.
Lordship will kindly
There's
say
a
order dated
complication.
2/2026.
Huh?
Order dated 2/2026. 2/2026. Last motion, respondent authorities concerned shall release the gratuity entitled to the petitioner within next 10 days.
So means out of the pension remains to be released to the petitioner, only the final pension and gratuity remains to be dispersed. Huh?
Yes.
It's already the responding authorities concerned shall release the gratuity entitled to the within next 10 days.
10 days. It is, this order has been passed on 2/2026. Till date, it has not been released. Now they are saying that they will review the penalty.
Then 18 it you have not said so anything. Subsequent date you have not said anything.
Subsequent on 18/2/2026, they are making a submission, they want to review my penalty.
Ah.
That is why this honorable court passed an order
Ah.
that they have to take the instruction, appropriate decision as may be taken. This order has not been reviewed.
You are supposed to take the decision.
Yes, my lord. That's why, my lord, this instruction has been placed, my lord. So we have taken.
No, it doesn't say anything. You simply says that, see, in view of the so and so, obtaining the views to the proposed penalty to be inflicted on so and so, receiving the views from Assam, so file will be endorsed to the judicial for betting and order if so and so in view of your. What is this?
My lord, after obtaining approval from the APSC, after Assam Public.
It's okay. This 18/2/2026, the respondent to take all approved decisions as may be deemed fit in the matter before next date of listing.
Have moved the file, but we have not received the file back from APSC, my lord.
When did you move it?
My lord, after 18/2, the exact date I will have to obtain, my lord.
Cannot be allowed to linger like this, sir. And you are supposed to pay them on your own submission.
Payment will be because if it is a major penalty, my lord, if it is a dismissal from service, my lord, then the.
It's not a dismissal, sir. It's only reduction.
No, it has been reviewed, my lord. After review, my lord, the proposed penalty, and that's why, my lord.
What is the proposed penalty?
It is not revealed yet, my lord. So after taking a decision, it can be done, my lord.
Then why you said that it will be paid within 10 days?
No, my lord, I did not say, my lord.
But court has directed you.
Yes, my lord. Thereafter, on 18/2, I submitted before the court that, my lord, that penalty has been reviewed, my lord. So now, my lord, it can be paid. Suppose, in case, my lord, in case the penalty is not dismissal or otherwise, my lord, obviously the petitioner will get his salary. But if it is dismissal, from where the department or the government will recover, my lord. So within a short time, my lord, the decision will be taken.
And see, what is the provision of review? When the appeal is pending, can you have the parallel proceedings? There is the statutory appeal provided to the petitioner, and they filed an appeal against the penalty. So what is the provision of review?
My lord, it may be tested thereafter, my lord. Let an order be passed, my lord.
Who is stopping you? Since you have imposed the penalty in 2022, and the man has retired in 2020, then?
So now, my lord, in terms of the order dated 18.
Sir, we are granting you further 10 days. You take a decision. Not later than that. Heard Mr. S.K. Goswami, learned counsel for the petitioner. Next para. In terms of the order of this court, dated 18/02/2026, Mr. D.P. Bora, learned standing counsel. Health and Family Welfare Department. Plus the instruction dated, a copy of the instruction dated 13/03/2026. Please stop. perusal of the same indicates that the matter has been endorsed to Assam Public Service Commission for obtaining the views to the proposed penalty to be inflicted on the petitioner. And after receiving the views from APSC, the file would be endorsed to the Judicial Department for vetting of the departmental, yeah, this is what they are. Departmental proceeding disposal order. What does it mean? For betting, huh? Betting. List of this court on 18 and this court on 02/02/2026 has directed the respondent authorities to release the gratuity entitled to petition within next 10 days. List of thereafter on 18/02/2026 directed the respondent authorities to take all appropriate decisions before the next date of listing. List of next paragraph. It is informed. No, it is submitted by Mr. Goswami and Council Board petitioner, despite despite order of this court for release of gratuity within 10 days, nothing has been released to the petitioner and no any order has been passed. The list of next paragraph. He also submits that an statutory appeal, departmental appeal is pending before the appropriate appellate authority. Next paragraph. Considering that the petitioner has retired in the year 2020 and the penalty has been imposed against the petitioner on 29/03/2022. It would be appropriate to direct the respondent authorities to pass appropriate orders, take decisions appropriately within a period of 15 days from today. Huh?
Yes.
As indicated in the order dated 18/02/2026. This is the matter. After 15 days, you advise them to take a decision. Cannot keep on hanging. Yes.
Right, my lord.
Yes, sir.
My lord. I am a lecturer of Assam Engineering College, my lord, in Electronics Department. In the year 2008, my lord, I went to Kharagpur Engineering College for prosecuting my PhD degree, my lord. The dean of the state university, my lord, wrote a letter, my lord. It is Annexure 1, my lord. Page 14. As per that letter, my lord, in para 2, it is written, my lord. The admission to the program is subject to your employer sponsoring authority of your college institute agreeing to treat you as on deputation for 3 years with full salary and allowances as applicable. On the basis of this letter, my lord, it is Annexure 2, my lord.
period of duty under, what is QIP is what?
Quality Improvement Program,
Quality improvement
Improvement
will
Program.
be treated as on duty with pay without stipend and other benefits for normal duration of pay. Yes, then?
That, Annexure 2, my lord. I
Ah.
was allowed to go for the QIP at IIT Kharagpur, my lord.
As on duty with pay without stipend.
Without stipend, my lord. Here is that.
Then?
But in the letter, in Annexure 1, my lord, with full salary and allowances,
Where it is?
in para 2, my lord, in Annexure 1, page 14.
The admission to this program is subject to your employer sponsoring authority of your college institute agreeing to treat you as on deputation for 3 years in full salary and allowances. Yes.
Yes, my lord, but
What do you mean by stipend?
My lord?
Stipend. It also says so that on duty with pay.
with full salary and allowances, my lord.
Yes, then?
But as per letter 2, my lord, they have deducted 6,000 per month,
For what?
which was given as stipend scholarship in IIT Kharagpur, my lord.
Yes. See, when it is without stipend,
Yes, my lord.
if you have been paid the stipend, you have been paid.
No, no stipend was paid, my lord.
Huh?
It was paid by the university only,
Ah.
not by the respondent, my lord.
Hmm.
Scholarship was given by the.
Whether you have been paid stipend or not?
Yes, my lord, no stipend, my lord. Scholarship,
Huh?
scholarship, my lord. That was given by IIT Kharagpur.
Plus your salary. I mean pay. You are getting pay.
I am getting from the state government, my lord.
Yes.
Then
it said stipend, it could be scholarship also.
My lord, it is not given by the state government, my lord.
That's why. But then
in
it's
other cases, my lord, kindly see, my lord, page 18, my lord.
Ah.
In those cases, my lord, no such direction was given.
Period
It
of
deduct
study under
stipend.
QIP will be treated as on duty with pay without stipend and other NHS for normal duration of the course. Yes.
No
same
direction
thing.
was given.
Same.
In the other scholars, my lord, in case of other scholars.
This is of what? You
Yeah,
are?
is other scholar, AK Das, AK Dev. No, my lord.
Sir, it's a period of study under QIP.
Oh,
Will be treated as on duty with pay without stipend and other benefits for normal duration of the course. Same language,
but
page,
both had-
page 16.
in my case, my lord, in page 17, kindly see 2, para 2. There is a direction to the principal to deduct this amount, my lord.
Yes, they might not have got it same.
In 18, my lord, in other cases, my lord, other scholars cases, no such direction was given.
See, where is the deduction? Where is the deduction?
It was deducted from my salary, my lord.
How do you know? Show us. Deduction is time and amount of probable but where the assistant professor elected in the Hmm?
My lord, I have not added this.
Have you received the stipend
That is,
during that
that is
period?
scholarship, my lord.
Huh?
That is scholarship.
We don't know, but then they say that you have received the stipend, therefore it has been deducted. Because your condition of the go for this
in the-
study, what is call it?
In the letter, my lord.
Sponsoring your college treat you as stipends for 3 years will full salary and allowance as applicable.
My lord, in that letter, my lord, there's a full salary was written, full salary and allowances.
Huh? Without the stipend.
In that letter,
And
given,
you have received 6,000 stipend.
but it is not deducted in other scholars cases, my
We
lord.
don't know. We don't know.
My lord,
The
kindly-
others might not have received it.
Well, kindly write page number 32, my lord, Annexure 8,
Huh?
Annexure 8, my lord.
Huh? What does it say?
The Director of Technical Education wrote the letter, my lord, to the Additional Secretary of the Governor of Assam. In the last line, my lord, they have written, concerning all aspects, I would like to recommend
Where it is?
government to needful for allowing
Page
page 32
30?
to
Hmm.
draw the deducted stipend amount from necessary.
Okay, it's on your letter only.
Director,
Considering the all, I would like to recommend government to do the for allowing Ms. Parot to draw the deducted stipend
Yes,
amount with necessary instruction. How can you do that? How can you be deducted when it says without stipend? How can you be allowed? It's on letter only, just recommended. That is wrong.
no, my lord, it is not the money of the state government, my lord.
Doesn't matter.
It is
Ultimately,
purport to
Kharagpur, the IIT where you have undergone, I mean, the study program,
Yes,
is it a private institute?
no, it is a government institute.
Then,
The-
whether it's central government, this government, that government,
state
money is public money.
It is state government, my lord.
When you have said
It's not
that,
their
you,
money.
no, when you have been agreed to the terms that you will not be without stipend, and once you have received it, obviously they'll deduct it.
No, my lord, it is a regular, in my case deducted, but not in other cases.
I don't know. If they have not been
I manage
deducted,
the documents, my lord.
suppose they are also not, they are also not entitled for a stipend, right? Suppose
Yes, my lord.
your colleague, those same persons who have been allowed to draw a stipend on the same terms and condition, right? If they have not deducted, it's up to the state.
They have got their scholarship, my lord. They have
Huh?
also got their scholarship.
Is it a stipend or scholarship?
This is different thing, my lord. Scholarship and stipend is different thing, my lord.
How? They say deduction is a stipend.
No stipend was given by the government, my lord.
Huh?
No stipend was given. Scholarship is different thing, my lord.
Scholar, I understand, but then what do you say? They say deducted stipend only.
Stipend, no stipend was given, my lord.
Page 32 clearly says so. It doesn't say scholar. You are relying on this page. I would like to recommend government to do needful allowing so and so to draw the deducted stipend. Deduction of stipend amount of so and so, so and so. Page 32.
32, my lord.
Nobody, it doesn't indicate any scholarship.
But this amount was deducted, my lord, from my salary.
Obviously, when you are not entitled for stipend and when you have received it, they should be deducted.
But I should be equally treated with other scholars, my lord.
No. I'm not impressed. Hard
But-
mister. That's all.
No, my lord.
For disposing
I
of.
was differently treated, my lord. I was.
See, suppose similarly situated persons, they have illegally drawn the stipend,
Yes, my lord.
which they are not entitled. It is not deducted. You cannot claim, equality
But
or
it is-
parity with them.
It is not their money.
Because very simple reason is, there is no concept of negative equality under Article 14. They have not done it. We cannot force them. They ought to have been. They should have been
It
deducted.
is not the money of Assam government, my lord.
Doesn't matter. It's a public money. Once you have not allowed, in certain then once you have received the stipend, deducted properly. That's all.
Oh, my lord.
That's all. On certain terms.
Yes, my lord.
that you will be only entitled for pay and allowances,
On the
right? Without
Yes,
stipend,
my lord.
and you have received the stipend, it will be the stipend.
On the basis of Annexure 1, I was allowed to proceed with my PhD degree. my lord.
Then second page,
Annexure 1, my lord.
Annexure 2, what does it say?
This is the disparity in this letter, my lord.
No. This is of 20th December. Then
The disparity given is in this letter, my lord, to deduct this amount from my salary.
this is
But on the basis of this
January.
thereof, my lord.
No, on this basis, page 16 only you were sent.
On the basis of 14, my lord, I was allowed to.
What about 16?
16 only in this disparity is given only in this letter, my lord.
Huh?
Only in this letter, not in case of other scholars, my lord.
Subject to your employer sponsoring authority at your college institute agreeing to treat you as deputation for 3 years with full salary and allowance as applicable. You are entitled to scholarship rupees per month for first 2 years and rupees 6,000 per month for third year on recommendation of the doctoral person and an amount of rupees 10,000 per as per continuing grant basis. You may please note that after joining the program, if the study cannot be conducted in the so and so. This is by whom?
My lord.
Professor Ajay Chakrabarti, Dean CEP. And it's the approval has to be by the government.
Yes, go.
So government has granted you, allowed your this permission with these following conditions. And you have accepted this.
I didn't have
This
them.
is the offer by your dean only, page 14.
And thereafter, immediately.
Then it has to be approved by the government only.
By the
Isn't it?
government, on the basis of that letter. Annexure
On
1,
the
my
basis of this,
Annexure 1.
this is a letter by the annexed, one is by the dean,
By the dean,
Professor
he has-
Ajay Chakrabarti, Dean CEP. And it has to go to the government has to approve you. Accordingly, page 16.
Yes, on the basis of this letter, my lord, there it is clearly written that with salary, full salary and allowances, my lord.
But then it has to be approved by the government. You are not challenging this.
I am challenging this letter, my lord.
No,
How can they
you are
that,
not challenging. You are just
No,
seeking that. Huh?
As per this letter, I was allowed to draw my full salary, my lord, with allowances.
See, page annexure 14 is a proposal and the offer to you by the dean.
By the dean, my lord.
Dean of the
On-
IIT,
on-
Kharagpur.
on
And the
this-
government has to approve
On
you.
this basis, my lord, on this basis of this letter,
See.
they allowed me.
Page 16.
Yes, my lord.
Immediately next month. It was a month of January, December 2007. And page 16 is 22nd January 2008,
Yes, my lord.
where you have been allowed for 2008 to 2009.
At that time, I didn't have knowledge that it was deducted, it is
Can't-
not
can't
deducted
help
in other
it.
cases.
Can you go without the, just because Dean has given you a proposal, offer, you just go without the approval of the government? Can you?
My lord?
Can you go?
Oh,
Can you go for this program without the approval of the government?
government is to approve, my lord.
So,
It
this
is
is approved on this certain terms.
Approved on this basis, on the basis of this letter, my lord. This proposal given by the dean of Kharagpur.
Therefore, they have approved in certain terms and conditions. It is the final authority. Without the approval of the government, you cannot go, na?
In my lord, there is a difference between scholarship and this stipend, my lord.
Ha,
Different thing, my lord.
ha,
Both are different things.
ha.
Scholarship is given to the scholars by the university, my lord.
Ha.
And the stipend is given by the government, my lord, employer.
So you are saying that you have not received any stipend?
No stipend, so they cannot deduct, my lord.
Ha. They have deducted the stipend only, not the scholarship.
It is not, it is, my lord, from my salary, my lord.
Huh?
No stipend was given, so they cannot deduct, my lord, this amount. As I did
Deduction is stipend,
stipend, but I did not
not the
receive the
scholar.
stipend from the government, my lord.
not the scholar. We don't know. Because your condition says that without the stipend, and the deduction is of the stipend. Principal Assamsi is requested to
Madam,
release Mrs. Parasho lecture in them to enable her to join so and so. Huh?
My lord, I
Will
want
be
to,
the period will be minus the stipend amount so and so for 2 years and 6,000 for the third years.
my lord, I want to annex the document, my lord.
What is it?
The deductions, my lord.
Huh? It is said what?
It is deducted, continuously deducted from my salary.
Deducted of what?
Salary, my lord, from my salary.
Of what?
6,000.
Of what?
Nothing can, but recovery. I paid.
No, they said it's a stipend.
It will be clear, my lord,
Hmm.
if I annex the document, my lord.
We are not disputing. They have deducted 6,000, 6,400 because it is a stipend
No stipend, my
you
lord.
have received, which you were not entitled, while the approval was granted.
No, my lord, I received scholarship from the university.
Hmm.
No stipend from the government, my lord. There's a difference, my lord, between these two words, my lord.
From where we can say that you have not received the stipend.
No such document, my lord. They could not file that the stipend was.
Let us
given, my
see
lord.
what is your scholarship? How you have received the scholarship? 6,604. You are saying that it's a scholarship.
Scholarship, my lord.
Show us any documents that 6,000 and 6,400 was a scholarship and not a
By the
stipend.
university. Right now, the document is not.
There is, there cannot be. It's a stipend only. Although you are saying that it's scholarship.
No, it is in this letter, my lord, letter entitled page 14, annexure
That
1.
is your, yes, sir.
My lord,
It's a offer by the dean of the IIT.
yes, my lord.
And to go for that program, you being a, where you are? You are where?
I'm
Where are you?
lecturer.
Lecturer
of engineering college.
of the engineering college.
Yes, my lord.
The government has to approve you
Yes,
for
my
this
lord.
program.
On this
And
basis,
the government has approved on this certain terms and condition that you will be allowed for.
that should be as per law, my lord.
Huh?
As per equality.
This is as per the law. You
As
have
per-
approved after the approval.
No equality has been observed.
You have gone for program in 2008
Yes,
and
my
9.
No equality has been observed, my lord.
What
No,
equal?
I was not equally treated with other scholars. my lord.
Same thing, page 18, you see.
No.
Period of study under GIP will be treated as on duty with pay without stipend and
Only
other.
in my case, it is.
Huh?
The deduction was only in my case, my lord.
Because you have been given, others have not been given.
No, they also got. my lord.
From where? So show us any documents.
The annexure 1 says. Annexure 1 says, my lord.
Annexure 1 said it's just an offer. If you say that it's not a stipend, you show
are
us the how
entitled-
you are paid the scholarship. Any documents to show that?
It is as per document, annexure 1, my lord.
Sir, this is simply an offer by the IIT.
Yes, my lord.
The government has to approve your this study or the degree, whatever you had to go there. Dean has proposed this, and the government has approved you to go there
Yes, my lord.
in certain conditions. Pay minus the stipend. According to the government, you have received the stipend. Therefore, it has been deducted.
That is not stipend, my lord.
Show us.
Confusing with this or not stipend and scholarship. Both are different things, my lord.
I understand. Please show me that you have received the scholarship. Any documents?
I have not annexed such document, my lord, here.
You don't have, you cannot. That's why you have not
Was
annexed.
given by university there, my lord.
Huh?
At Kharagpur University given, my lord, where I was prosecuting just study.
We'll record your submission and we'll dismiss the writ petition. You are not entitled. You have accepted it and it is deducted. That's all. All right.
No, my lord,
Heard, Mr.
my lord, I have objection, my lord.
I have heard,
My lord, some time may be given, my lord.
I have heard
shall-
you enough
My lord.
since
some
last
time
20,
may be
20,
given,
30 minutes.
So that I can produce the document,
No.
my lord. My lord,
Heard, Mr.
I see the card. After review, my
You
lord,
file
I can take a.
you file an writ
I shall.
appeal. You file a writ appeal.
My lord.
I have given you enough opportunity. You are trying to take advantage of the words of the
Different.
different authority, dean and the government. Who will pay you? Who will pay you the salary?
Salary by the government, my lord.
Who will pay you the stipend?
Stipend was given by university. Stipend, a scholarship.
Hmm.
Scholarship was given by the university.
Show us that these amounts which you have received is a scholarship, not a stipend.
That is not stipend. Stipend is given by the government.
No, us, no. We'll immediately allow. We'll immediately allow your writ petition if you can show that these 6,000 and 6,400 which you have received is in the form of a scholarship, not any stipend.
This annexure 1.
You yourself has a deduction or a stipend. You yourself has said so.
No, my lord. This
Page
letter
80, page 32. Page 32, which you are relying.
Yes, my lord.
Page 32.
They have allowed to.
Page 32.
Yes, my lord. I'm
You
saying.
just write. See,
I have 30. They have
deduction of stipend.
to needful to the stipend amount.
Huh?
They are confusing with this word, my lord. Stipend and scholarship.
Yes.
Lordship, in Excerpt 14, though the word scholarship has been used here, Lordship. Lordship, it is in my humble understanding, Lordship, it's a general format. It is format for the regular students. But here the petitioner is a Lordship employee. So this scholarship itself is a stipend, Lordship. And moreover, Lordship, page 16. Moreover, page 16, it's categorically stated that the period of study in QP will be treated as on duty with pay without stipend, and she has voluntarily accepted it. After accepting it, Lordship, after going through the program 3 years, after accepting the money and conditions, everything, Lordship, now she cannot resell it, in my humble understanding, Lordship. We have not-
But then see,
Yeah, Lordship.
if the stipend has been not provided to you, if it by the AICT as a scholarship, how can you deduct that?
IIT. This is the IIT. So before that, Lordship, this was the proposal given by the IIT.
No, in terms of AICT circulations,
But after
circulars.
After perusing this Lordship, this proposal, government has decided, the government has gone through it. Then only they have issued this approval letter. Wherein they have categorically stated the amount also, page 17. The principal Assam Engineering College, Jalukbari, Gauhati, she is requested to release so and so lecturer in electrical so and so. Her pay during the period will be minus the stipend and amount and of rupees so and so 6,000 for 2 years, and it is categorically stated. And moreover, my senior friend has been saying that other persons has not, the deduction has not been done. For that, Lordship, page number 36 may be perused. Wherein this anomaly, when finding this anomaly, we have directed the principals to deduct if some deduction has not been made to others.
Page-
Page 36 of the Recruitment.
36?
Sir, have a representation
Huh?
at page 36. May I read? To the all principals. It is addressed to the all principals of Engineering College of Assam, Lordship. Deduction of stipend amount of the faculty members who are undergoing higher quality under QIP program. Sir, I am directed to say that as per OM dated so and so of 2006, this OM is of 2006, issued by the Education and Higher Technology Department, the period of study under QIP is not to be treated as on duty with pay without stipend and other benefits for normal duration of the course. You are therefore requested to follow the aforesaid OM and deduct stipend amount and other benefits received by the sponsored candidates who had undergone higher study under QIP if not deducted earlier. So this instruction was also there.
My lord,
So
this
at this
is
stage,
not implement as yet, my lord.
It's up to them.
Not realized as yet, my lord.
So, see,
This money.
as per the requirement, if it is to be deducted, maybe they'll
it is to be
recover, they are
deducted.
not to be, it doesn't
They-
make any difference.
They could not produce any document that it is deducted from other scholars, my lord.
No, that's it, it is more than enough. Where is OM? OM, that is OM 19/7/2006?
with me, Lordship, but this is mentioned here. It is their document. They have annexed it in their.
Period of study
Education.
under QP is to be treated as on with pay without
It was
stipend.
prior to the approval, 2006.
Subsequently.
This OM was of 2006. In terms of this OM, this conditions were Lordship incorporated in the approval order. Now, Lordship, after receiving in our affidavit also, we have clearly stated all this. After receiving, now she has come with that idea that
2012.
refunding.
He passed this order after 6 years.
No. OM is of 2006.
No, this was for
Yes, it-
deduction for other
Well,
scholars.
no,
It's
such type of
given
complaints
in
were
2012, but till date, it is not executed, my lord.
Doesn't make a difference. Whether they are deducting or
I-
not,
I
but
think
once
it
they
will
have
be
once they have the power, authority and as per the OM to deduct the
lord.
stipend,
We are equal,
in
my lord.
case if they are not getting it, I mean deducting it for others, if they have not recovered or deducted, it doesn't make any difference.
But
First, you
I-
have to show that you are
I
not
should be equally treated, my lord.
you are
as
not
our
no
article.
equality doesn't come into play, but you will have to show that they cannot deduct the stipend which you have received, right?
No,
Although you are trying to say that it's a scholarship, but then
process is different thing, my lord. The university, given by the university, different money. They have not reimbursed this money to the university.
Huh?
They have not reimbursed this money to the university, my lord.
We
It is the
don't
money
know.
of the university.
We don't know. Once you are not entitled and once you have received the money as an stipend,
That
You are
is
not.
the money stipend is totally different thing. It is given by the government to the employer.
so I've deducted as a stipend only.
No, no.
That's why
stipend.
I told you to show that the amount which you have received is an scholarship.
No, I have not. I received a
So as-
scholarship.
Then show us.
But there is a difference, my lord. It is given by the university. as-
Show us
My lord.
that it is you have whatever the amount you have received is an scholarship, not the
It
stipend.
is a scholarship.
Show us. Show me any documents.
I have to find that document again, my lord.
Huh?
I have to find this document and annex that document.
But mister, just write it down. Yes, mister.
I see data.
I see the learned counsel for the petitioner and also heard Mr. A.R. Tavildar, learned standing counsel. Higher and
Technical.
higher education, bracket technical department. Respondent Arcade Talukdar for respondent number 5. What is this? Huh? Standing counsel. Standing counsel so and so. Huh?
My lord.
Thirty-six clearly says regarding the equality.
By filing this writ petition, the petitioner has prayed for a direction to the respondent authorities to reimburse the deducted stipend amount from her salary on account of the, what is called? On account of the what is called is? Huh? Quality improvement
Program.
program. Which she has undergone.
Or higher studies in PhD degree course.
I studied in PhD degree course during the session 2008 to 2009 under quality improvement program at IIT Kharagpur for a period of 2 years. This stuff. We'll pass the order.
Oh, my lord. Sir, only one such may be given, my lord.
Huh?
I shall
No,
put
no,
this document.
I have heard enough. We'll pass the order. Huh? Yes, just wait, just wait. Mr. Tiwari. Biswas.
Yes.
Just wait. Sir, just wait.
My lord, the witness.
You have no witness, witness
Yes,
has
yes,
come.
yeah, my lord. He is here.
See, why am, this court had to rise around at 2:45. What to do?
Because first of all, they have also filed an application because documents have to be proved, first of all, completely. Then only because cross-examination can't be in a piecemeal fashion, that 4 documents they have proved today, 10 documents they will prove some other day. Only when the documents are all proved, I know what it is all about. Because there is always a connecting link in the questions. One question may be connected with the 15th question. So that is why they have also filed an application. Many other documents have to be brought in. Some of my
That is only.
Any more
because-
application?
No, no, that application is for the reissuing of the summons, because my lord, what has happened, your lordship has issued the summons to the official witnesses.
Yes.
They have to produce the documents. They were supposed to produce the document on the last occasion in the Itanagar bench, my lord. But now, my lord, your lordship is sitting here. So
Yes.
that document, those official records have not come today. But there are other records, the private records, which are already on the record of this tribunal. So on the basis of that, the cross-examination can start.
No.
The cross can
can't be.
start. And because otherwise this will unending, my lord, this will never happen.
My
Because
lord, some of
because
the
it will
questions
happen,
will be
happen,
on the
it will
basis of
happen.
videography.
See, difficulty is this court is rising today or day after tomorrow.
yes, my lord.
Tomorrow, today or tomorrow, rising at 2:45, only for 45 minutes. It will be difficult to have the piecemeal one for one
I agree, I agree,
witness.
I agree, my lord.
So I
just want-
may I suggest that it's not that don't say this, make a submission that it will never happen. It will happen
What
definitely.
my lord?
So what I will suggest is, we don't have the original also.
Yes, yes.
Of course, I have the photocopy. I mean, scan copy I have, the court's record.
That cannot be had.
Can we fix the matter
Yes,
from 6th of April?
yes,
6th of April.
yes.
6th of April,
Yes,
kind
yes,
of
yes.
at least day to day we can start
Yes, my lord.
from
Absolutely.
6th of April.
Yes, my lord.
6th of April, then thereafter I'll be there for another 2 or 3 weeks. We
In
can
Itanagar-
continue.
Itanagar, my lord. Very good.
Apart from other cases, we'll obviously take it up. At least from 2 o'clock we can take it up.
And lordship may summon the witnesses.
Just wait,
The
just
documents
wait.
there at
I'm
6.
just suggesting, because today too practically it's not
I
possible.
agree, my lord.
2:45 were
I
rising.
bowed on, my lord. I more difficult.
Isn't it, sir?
Because lordship directed the witnesses here, but I bowed on, my lord. Because on 6th.
I
something
we
was
paid
taken.
for this. It's yes.
Now, my lord, and one more important thing, namely, some of the questions will be on the basis of a videography because there are factual aspects. I will be asking certain questions to PW1, the respondent, which are on the basis of the scenes recorded in the videos. Now, the videography, my lord, the original record are in the Itanagar bench. Now, apparently, my lord, that videography has to be played. And then the questions will be asked on the basis of that. So, my lord, we have to find one common platform, whether it is here or whether it is there.
My lord is suggesting that's why. In
Please,
Itanagar.
please, sir, let me kindly. So, my lord, if my lord is sitting in Itanagar, then, my lord, all the original records are there. Even the videography can be played and the questions can be asked.
70.
That's one part. The second part is, if by 6th of April, all the documents which are connected with the evidence of PW1 are proved, all are, whatever they can prove, they are able to prove. If that part is complete, I know where do I stand. I know what are the documents which are the basis of their foundation of their case. On the basis of that, I can build up my style of cross-examination. So, my lord, if my learned friend is sure that the documents he is calling for by way of summons will be here before this honorable court, either on 6th of April or prior to that, then, my lord, from 6th April, cross-examination can begin. There is no problem whatsoever.
Very well, my lord. Lordship will issue summons to the government. They will bring the records. Officials are bound to bring the records on 6th.
I think that issue we have heard you last time that's why we came to this order was passed fixing the date today. But it is not your fault, either of you. It's the intervention of unavoidable such a situation.
Reason. The council who is instructing me and getting entire feedback from the local place.
These are all-
Our Rinchin Lido, his father is in ICU. He's in Gauhati only. Rinchin Lido is in Gauhati. His father is in ICU. So that's a separate matter altogether. But I hope it will be sorted out by that time. That's other way. Absolutely.
In fact, the circumstances, this court is also not happy. But can't help it. I cannot avoid it. It's unavoidable. What can we do?
Logistical problem, my lord. That's
It's always there.
housekeeping
These
part.
things happen.
My lord, that we have to.
So 6th April will not be take it. I
We'll
hope.
start from 6th April.
Yes.
Suppose, in case I'm expecting perhaps I'll be there. It would be better there
Yes.
Yes.
because of all this
Witnesses
logistics.
are also there, my lord. Documents are there.
Originals are there. Videography is there.
Then another after the break, 10 days I would like to continue there for this, but this purpose only.
Very
There's another matter also.
It will suit us also.
So then,
On sixth, my lord.
on 6th.
And my lord, the summons has to be reissued for sixth to the official witnesses,
Yes.
my lord. That IA we have filed, that is the IA.
For issuance of that.
Summons,
Yes.
sir. And there, my lord,
No issue.
Huh.
Fine, sir.
and there, my lord, these, because on February 2026, Lordship had passed a separate order allowing our some additional documents.
Yes.
So there are 5 documents in that order
Hmm.
which were not part of the original summons because that was allowed only on February. Original summons was issued November 2025.
Hmm.
So therefore, these 5 records which are official documents needs to be included in the summons, my lord, order.
Were
That's
they
all.
part of the
Yes, yes,
election
yes,
petition?
yes. They were allowed by the February 2026.
I take your words. If that be so, fine.
Have you not added these documents here?
Yes, yes, my lord.
Yes.
Your
You
lordship's
have- in the-
order.
in the
yes,
IA you have added.
Yes, yes. Lordship has allowed this.
No, if
All
my
part.
London friend says so, I accept it.
We have cross-checked.
Well,
We have cross.
if you have cross-checked,
You should not have
Doesn't
any doubt
matter.
on your colleague.
no, I never do. I never do. That's why I asked him. If he has cross-checked, it's perfectly okay.
Okay.
So.
Well, sorry for the petitioner.
Not at all, my lord.
He's happy, my lord, he's happy to have the ambience. He's preparing himself for the stage.
There are certain issues, circumstances, which we could not avoid. So it's not lawyers or any petitioners or the parties. Probably it's a problem with the court. So you bear with us.
Exposure to the honorable court will put him in a good position next occasion.
And the learned council also. Learned council.
Both ways, both ways.
So we'll pass the order here only. Yeah.
Yes.
Yeah.
Yes.
Heard Mr. Rituraj Biswas, learned counsel for the applicant petitioner, election petitioner. And also heard Mr. PKT, learned senior counsel for opposite party respondent. Huh? By filing this application, the applicant of the election petitioner has sought for issuance of summons to produce documents. The documents sought to be produced is other. Where it is these documents?
Yes, my lord. This is at page 13, my lord, of the IA.
Hmm.
Is the judge order, my lord, whereby initially the summons were issued on November.
Hmm.
Page 14 onwards, my lord, all the documents are mentioned. Page 14, page 15,
Hmm.
and the name of the authorities are also mentioned in this order.
Hmm.
So this has to be repeated, my lord.
Huh.
In addition to that, these 5 documents, the
Ah.
list I have given.
For the following, no.
These are in the
Just right there. The documents sought to be.
रेफरेंस अगर दिए होते तो उसमें तो अच्छा था थोड़ा जब मैं टैली करने
No,
में
no, you just said the
petition का तुमने रेफरेंस दिया होता ना उसमें दे होता तो मेरे लिए easy
authorities.
रहता। ना पड़े।
No, to issue summons or to produce the documents set as under, huh? For the following documents, huh? Page 13, huh?
Page 13 to page 17, my lord. All documents
All
are
the
mentioned.
documents, and then you add this also, huh? No. You have mentioned the authorities also, right?
Yes, my lord. Yes.
Election Commissioner Swains, huh?
Address with address I have mentioned.
Or make it not 6, we'll make it 7, huh? On so and so, give the date, huh?
Yes.
We'll fix the date, not 6th, 7th.
7.
There's a reason I'll tell you later. Why not on 6th?
Let it be 7th.
The petitioner may not know. May know. Why are you fixing it on 7th? Why on 6th? Not only the petitioner, respondent also.
Then I'll find out.
Why not immediately after 5th of April?
All right.
in view of the order passed so and so, election petition, will list it on 7th of April.
My lord,
I am on lighter note, don't take it seriously.
my lord, his presence may be recorded, my lord,
Okay.
and he may be bound to appear.
Ah,
It is in his interest to appear.
But he's a witness, he's under
So
the
in that
order.
case, Mr. So-and-so, Tadar Manku, election petitioner is present. That's all.
Grateful.
Still 15, where on 15?
May not be. Lots of pleadings has been completed. The case is otherwise ready. So
15. What is the matter?
matter was actually petitioner which for your lordship, she was a lecturer of the one college in Naharkotia College. So she was applying for the leave, medical leave. She was absent for some times. Then after when she was intending to join, she applied for joining. Then she was not allowed to join. Rather, she was directed to appear before a medical board constituted in Assam Medical College, Dibrugarh. So accordingly, I appear before the medical board. So medical board, they have examined me, then they have released me. Thereafter, I insisted for joining, but I was not allowed to join. Neither medical report was handed over me to. Like this, it was continuous.
When did you retire?
22.
Till the,
So during
since 2010,
yes, Lord, that's a very interesting, Lordship.
12 years.
The medical, no, I was intending to, affidavits are there, or everything are there, proofs are there, that I was intending to join, but they were not allowed me to join. Lastly.
What is
when
their stand?
Their stand, I'll, because, Lordship, this is a list of bits, or your Lordship.
Can you dispose it of today?
Lordship?
Can we dispose it of today?
Yes, yes, fine.
Madam, D. Gogo is appearing a lot, which is late. So, Madam, may have taken up some of the, so hearing a lot. Otherwise,
Lordship,
pleadings are completed a lot.
From 4/3/2011, I was not allowed to perform duty. I appeared before a medical board. Thereafter, they took the decision after my retirement, because they have forwarded the medical principal, forwarded the medical report to the Director of Higher Education. The Director of Higher Education took a decision. Till now, it is not decided, but by this time, I haven't superannuated. That is my case, Lord.
So practically, you are not in a job.
No.
You are not in a job.
Not. I was not allowed to join the. So there are authorities of the Supreme Court judgment, three judgment. That's when I was not allowed to join.
Some other day, since your
Lordship,
council who is representing the state is not there.
Lordship fixed a short date because it is a 22, she has already retired. From 11, she was not allowed to perform.
But you have enjoyed your life without service.
Without money also.
Huh?
Without service, without.
Unless you work, how can you be provided with?
Lordship.
You have to work for that. Since you have not worked,
No.
how do you will be?
No, no, I am not. I was intended because documents are there. They have in the affidavit also they have admitted.
Yes.
I applied one after application I have submitted for joining. They have not responded. The document affidavits are there, Lordship. Documents are there. I can prove it, Lordship. Lordship, then
When did you file an application to join? When did you try to join?
from 2011,
2010.
2010, 2011.
Then thereafter?
They have not responded. They have
So
not.
you have just waited for 2 years. I mean 12 years.
No, thereafter they sent me for medical. So I appeared before a medical board.
When? Which year?
2011.
Then?
4/3/2011.
Then
Thereafter, no response. Neither medical fitness certificate is given to me. Fitness certificate is forwarded to the Director of Higher Education. They do not take a decision till now when I am retired. So for their delay, for their inaction, that I cannot suffer. That is my case.
since 2011.
Lots of proofs are there.
Proofs are there in affidavit, they have admitted, principal admitted that all records are forwarded to Director of Higher Education to take a decision, but decision has
And
not.
then you waited for 10 years. 10 years.
Almost. I have continued my correspondence. I have seek permission to join, but they have not allowed me to join.
It's very difficult. Anyway, heard Mr.
H. Rahman, senior advocate.
Then senior, then senior counsel, assisted by then counsel for the petitioner and Mr. R.I. Gogoi appearing on behalf of Mr. B. Gogoi and standing counsel.
For number 3 and 4, Principal, Narakotia College.
And Mr. As I agreed to by then counsel for the parties, let this matter be listed after 2 weeks,
Let it be fixed in April.
2 weeks
Date may be fixed. Lord.
and 3 weeks. Give that date.
9th of May.
21.
View is around.
21.
21. 4.
May it be the lordship, my lord. This is a case, my lord, where the petitioner, my lord, private respondent number 5, my lord, he was allowed to hold the post of the in-charge principal, my lord. Though, my lord, this private respondent number 5, my lord, he came to the school on his own request, my lord, around 3 months ago, my lord. So, my lord, as per the, my lord, rules, my lord, he forfeit his seniority, my lord. So, he is the junior most teacher in the school, my lord. But he was allowed to hold the post of principal, my lord. So, my lord, page 27 is the impinging order, my lord. My lord, may I kindly say page 27, my lord.
Yes.
In the interest of public, Sri so-and-so is a private respondent number 5, my lord, subject teacher of the so-and-so school, is hereby allowed to hold the charge of principal in charge of the same school along with financial power to draw and disburse the salary of the school in addition to his normal duties as subject teacher in under FR number is 49C by Srimati so-and-so, subject retired on 3/11/2023.
So you are.
So, my lord, I am in the school, my lord, since 2023, my lord, and 2003, my lord. So I discharged, my lord, more than 20 years of service in the school, my lord. Now, my lord, this petitioner, my lord, we have sought on the information on the RTI, my lord. He has come to that school, my lord, only 3 months ago, my lord.
When?
So my lord, my lord, may I kindly come to my
3
additional
months
affidavit.
ago, when?
Affidavit at page, my lord, 36. Additional affidavit I brought on record, my lord.
Jatin Gogoi.
Yes, my lord. These are letter, forwarding letter, my lord, and his own request transfer, my lord, at page 37. My lord, may additional affidavit.
Prabhat Deori.
Yes, my lord. Lordship, may kindly see nature of, my lord. I will read the third line, my lord. In persons of recommendation of so-and-so, and as per the provision of the Assam Elementary and Secondary Education Teachers Regulation of Posting and Transfer Act, the following teachers under Tinsukia district is hereby transferred as per his own request in his own grade and scale with effect from the date of his joining. So, name of the teacher is Prabhat Deori, is a respondent number 5, my lord. Lordship may see presently working Sodia government school, my lord, and transferred to the government girls schools. That is a present respondent number 4 school, my lord. So, my lord, Lordship may kindly see, my lord, when he was transferred 22nd of August. This is an order has been passed, my lord. And thereafter, my lord, Lordship may kindly see the next letter, my lord, at page 38, my lord. He was released from that school, my lord, on 31 of August, my lord.
It's okay. But
And
then
thereafter
how,
he joined,
how
my
you
lord.
say that on his own request, if
Yes,
he
my
joins other school, he becomes junior.
Yes, my lord. Now
Where it is?
Yes, my lord. I'm just.
Where is the provision?
Yes, my lord. I'm giving, my lord.
Are you eligible to be
Yes, my lord.
appointed?
I'm eligible, my lord.
Huh?
I'm eligible, my lord.
What is your degree?
My lord, I am MA, my lord, B.Ed, my lord. And I'm MA, B.Ed.
So private respondent,
And my
private respondent is MSc B.Ed.
Yes, my lord. But he doesn't have the seniority, my lord. My lord, this is not the regular principal, my lord. There is an in-charge principal, my lord. And settled position of law, if lordship kindly come to that one judgment of this honorable court, my lord, where it says.
Don't
Acha,
come to
okay,
directly.
before
jump
that,
to
my
the-
lord, I will go to that, my lord, notification of 2023, my lord, is a Assam Elementary and Secondary Education Regulation of Posting Transfer Amendment Act 2023, my lord. Lordship may kindly.
20 or 23?
23, my lord.
Yes, then
Lordship may kindly come to, my lord, the last paragraph, amendment of section 11, 5.
where it is?
That's next page, my lord.
You have given two.
One is, my lord, the original act, my lord, and the second one is the amendment act, my lord.
This one?
Yes, my lord, this one, my lord. Down below, my lord, amendment of section 11, my lord. It says, my lord, provided that the provision, my lord, provided that transfer of teachers made in his her own request under this section entail forfeiture of seniority, my lord. So, my lord, once he transfer from his own request, my lord, he will lose his seniority, my lord. So, in that event, my lord.
So what is the rules that the in charge principal has to be appointed?
There is no rule regarding in charge principal, my lord.
Then
My lord, that's why, my lord, I place one judgment before this honorable court, my lord. Lord, may kindly see, my lord, the judgment, my lord. Judgment of my lord 2000. This judgment of my lord, Honorable Justice B.K. Sharma, my lord, Lordship find WPC number, my lord, 669/2012, my lord. Party name hole ito? Yes, ito asile. Shashi Hajarika. I will just read the para 3, my
oh,
lord.
these are this thing. That's why I'm asking.
Yes, ma'am.
For in charge also, if he's equally qualified,
Yes, my lord.
what is the rule provides that seniority has to be given the preference?
My lord, two things are required, my lord. One is seniority has to senior most.
Under which
teachers.
rule?
This is not there. It's a subtle position of law, my lord.
I want the rule.
Rule, my lord. Lordship may
Not
kindly
subtle
see, my lord, the rule of my
This,
lord.
this you are showing is the for even for in charge or temporary,
Yes, my lord. Education qualification necessary, my lord.
one has to be qualified, eligible in all respect.
Yes, my lord.
Both of you are eligible.
Yes.
The issue is only seniority.
Yes, my lord.
If we accept that he was posted here
My lord.
in the present school
Yes.
on his own request, so he loses seniority. You may be senior.
Yes, my lord.
So in that case, you have to show rules that
My lord,
senior has to be given a preference, or for in charge, the seniority has to be counted.
My lord, I will
I
just
mean,
take-
the preference given,
My lord,
preference has to be given.
in the rules, my lord, my lord, for regular promotion, my lord, regular principal, my lord, the rule says.
Are
my
you
lord-
saying that for regular, he is not entitled,
Yes.
eligible?
No, my lord.
Then
He's not senior most, so he's not eligible, my lord.
how can, what's the rule?
So there is no
The
specific.
senior most has to be appointed.
That has been explained in the judgment, my lord. Lordship may kindly see, my lord, para 3 once, my lord.
Of what?
Of the judgment of my lord, 669 of 2012, my lord.
You have given this one this thing.
And there is another judgment, my lord.
With the honor judgment.
There is another judgment, my lord. There are 4 copies are given, my lord.
This maybe this one. No.
Asset short now. Lordship, I'll give you my copy, my lord. Lordship, can I take this copy?
There is no rule.
Yes.
The
There is no
seniors have
specific
been
rules,
given
my-
preference.
Yes, my lord. My lord, may kindly see para 3, my lord.
Yeah, I'm asking the rule.
There is no, the rules is only regarding my
There
lord.
is no
regular
dispute
principal.
in the normal circle. Senior most teacher of the school, irrespective of whether he belongs to graduate cadre, postgraduate, whether he is required to given the charge, the principal, in absence of any regular appointment. The question for recognition as to whether the petition is senior to entitle him to hold the charge. It's a normal circumstances.
Yes, my lord.
Then,
So normally, my lord, the senior most teacher has to be given the principal, in charge principal, my lord.
so
But my lord, in this case, my lord, since.
in
my
a
lord-
normal circumstances,
Yes, my lord.
in the abnormal circumstances, what will happen?
No, my lord. My lord, normally, my lord, lordship may kindly check the other, my lord, the judgment of this 22122 of 2023 that I have placed, my lord.
Initial appointment?
Initial appointment, I am senior to him, my lord.
How?
My lord, may kindly come to.
Forget about the coming to the school.
Yes. Initial
When
appointment, I am
when
senior.
you were appointed,
My lord, may kindly come to my petition, my lord, at page, my lord.
tell us when
Yes.
did you when you
My
were
lord,
appointed?
my joining, my lord, in the school, my lord, is on to 16/1/2011.
As MA BEd.
No, yes, my lord.
MA B.Ed.
No, initially, my lord, subsequently I done my MA, my lord. He also
Ah.
done B.Ed subsequently, my lord, MA subsequently, my lord.
Then when
But-
he was appointed?
I was appointed, my lord, on 16/1/2001, my lord, and
When
he
you-
appointed 18/1/2001, my lord.
How many days?
2 days, my lord. But my lord, he is a own request, my lord, since my lord, settled position, my lord, senior most teacher is
What's
basically.
the
estimated-
responsibility? Where's the law?
Law, my lord, this is a
It's
judgment.
given in on its own facts. So as the rule. If
My
the
lord,
rule provides that senior most has to be given even for principal in charge,
There is no
we'll
rule
consider.
regarding, there is no rule regarding, my lord, in charge principle, my lord. There is no rule, my lord.
Yes, why you are not filling up regularly? Is it merit come seniority or merit seniority come merit?
Merit come seniority.
Then you fill up regularly.
In Assam, secondary education government service rule 2020 would be applicable in this.
Yes, yes.
So as where is that?
My learned friend has produced before his lordship. I have not gone through. It was in respect of earlier rule lordship, where the school wise seniority was mentioned, if I am not wrong lordship.
They say normal circumstances,
Normal
they say.
circumstances. Assam
They are
secondary
not
education
referring
government.
there is no reference of any rule.
60 higher cover page 2, page 57.
Yes. Assam secondary education, government schools.
Yes, ma'am.
Service rule 20, yes. Rule,
The recruitment to the post of principal by promotion or criteria there. Page 67.
then
Then lordship, here lordship, at least the qualification is that lordship, the post of principal of higher secondary school shall be filled up by promotion from the candidate among the cadre of postgraduate teacher, vice principal, headmaster, and or graduate teacher, having educational professional qualification as per under sub rule 2. The
MSc,
candidate
MCom, BT, so
must have passed BMA, BT, B.Ed degree from the recognized university, having uniform good academic career for being eligible. So the candidate must have rendered 5 years service as principal or 15 years service as postgraduate teacher or 17 years service of graduate teacher or any government school, 10 year experience as headmaster government school subject or 17 years service as both headmaster and graduate teacher. That is must so and so. Both lordship are qualified for that lordship.
the age must not be less than 40 years. As on the first day of January, year of recruitment. How about the?
It speaks about the procedure of selection of principal. For the end of the each year, the appointing authority shall make an assessment of likely number of. So I am speaking.
So, my lord, this is important, my lord. This combined list has to be prepared, my
Yes,
lord.
yes, I'm coming. The principal so. 2, the appointing authority shall then furnish the state selection board a list of eligible teachers having requisite qualification and experiences under Rule 12 of these rules, along with the following documents and information as in respect of as many as 4 times so and so. And that information about number of vacancy, combined list of teachers eligible for promotion to the post of principal, character rule, etc. That rule 4 lordship. The selection shall be made on the basis of merit cum seniority and also the consideration of leadership skill, administrative ability, integrity, and commanding personality, etc. The detailed guideline in this aspect shall be issued by the government in secondary education department from time to time. So this was for the criteria for the regular principal. There is no criteria prescription for the in-charge principal.
Yes.
And lordship now would come to regarding the seniority, rule 24.
Of the same rule.
Yes, my lord.
Appointed by the direct recruitment or by promotion shall be determined according with the order of preference in the respective select list finally approved by the appointing authority under Rule 4.3 in respect of post of junior assistant peon laboratory. This is not relevant, lordship. 2,
3 is relevant, my lord.
if a member of service in the cadre fall to join in the appointment, no, 3 is relevant. The seniority of a member of a service in a cadre who join in a school otherwise than by direct recruitment or on transfer or otherwise shall be determined as per the date of initial joining of the first school in the concerned cadre. If a member join in the school through transfer from other school, the seniority shall be restored.
That is, the subsequent amendment has come, my lord, that seniority will go, my lord.
The seniority of
Amendment.
graduate school, so this is not relevant.
The seniority, my lord, that is relevant, my lord, because this, my lord, the act subsequently came in 2023, my lord, which says, my lord, if he go to on his own request, then he will not restore his seniority, my lord. He will forfeit his seniority, my lord.
Is there any graduation list?
Yes, common graduation list has to be prepared,
Where it is?
not prepared as of yet, my lord.
Lordship, I don't have edge on that, Lordship. Instruction I have
Yes,
received.
what is your strength?
Lordship, one instruction just now I have received.
No,
WhatsApp.
no, have you filed the affidavit?
Not
Just received, Lordship, I have received instruction.
What is that?
On
What
leg,
does it say?
Lordship. So I'll have to, Lordship, go through that, matter may fix that day after tomorrow, Lordship. In the meantime, Lordship, I will place.
Arey yaar.
No, otherwise after next week, I will file an affidavit on the basis of instruction I have received. Lordship.
This is senior annexure 4. Page 48, what is this?
Page 48, my lord,
Hmm.
48 or 43.
Draft gradation list.
So that is, my lord, regarding to particular cadre, my lord.
Hmm.
Since he is a postgraduate teacher, the draft gradation list has been prepared regarding, my lord, is postgraduate teachers. But here,
Are
my
you
lord,
not a postgraduate teacher?
I am a graduate teacher, my lord.
He's a graduate teacher.
Not postgraduate.
Not postgraduate. But my lord, the difference is only in my case, 17 years of experience is required. In the case of postgraduate, the only difference is 15 years experience, my lord. Otherwise, when the combined gradation list will be prepared, my lord,
No, no.
everyone will come.
You require 17 years.
Yes, my lord.
As a graduate
As a
teacher.
graduate teacher, my lord.
As
And he,
per-
as a postgraduate teacher is 15 years, my lord. As
So
per-
he is postgraduate.
He is postgraduate, my lord. So, my lord, in that event also, my lord, in the judgment, it is reflected, my lord. Since it is a, my lord, common gradation.
See, in that case, even if you are junior, I mean senior, if he loses his seniority,
Yes, my lord.
but being a postgraduate teacher,
My lord.
you will have the advantage of 2 years.
So, my lord, the judgment makes this clear, my lord.
So
because
how you have how
My-
many years you have completed?
in my case, my lord, I am almost, my lord, 23 years plus, my lord.
What about him?
So he also, my lord, if we they, my lord, count this, my lord, qualification, my lord, then he is okay, my lord. But as regarding to the seniority, my lord, because not only this merit comes
That's
seniority.
what I'm saying. It's okay. It's
Yes.
a merit cum seniority.
Yes.
Only if you are eligible, both of you will be
Yes.
considered merit cum seniority.
Yes,
Not necessarily the senior.
yes.
So what is your right?
So merit comes seniority is there. Combined gradation list has to be prepared, my lord.
It's okay. That is not done. But then you cannot just say that they are not eligible. He could not have been allowed to all the charges. See, it's all based on regular promotions or based on merit cum seniority.
Yes, my lord.
Where there's no reason to interfere. Only we may say that to fill up the post on regular basis.
Let him file
If
his
the,
affidavit. Let him file his affidavit.
if the post is required,
Let him
right.
file his affidavit, my lord. I think, my lord, is better, my lord.
Another.
you were
Yes.
interested to get the matter disposed of.
My lord, he lordship dispose, my lord. It's okay.
We'll dispose it on, we'll say, we'll not interfere the in charge. We'll say,
My lord-
if it is required, the government is
My lord-
at liberty to fill up the post on
So
regular basis, but the rules, that's all.
So what I'm praying, my lord, let him file his affidavit, my lord. So that I can
See,
reply to
just
that.
because you are not able to show that since you are senior, just because he has lost this seniority, otherwise he is eligible,
Yes,
he is also equally eligible.
yes.
You are not able to show that even for law is settled that even for temporary, one has to be eligible and qualified.
Yes, my lord.
It's not the case that they are not, he's not eligible. He's equally eligible.
Yes.
So, writ petition dismissed.
No, my lord, what I'm praying, my lord, let him file his affidavit, or this, only we can at least reply to that effect, my lord.
Huh?
We can reply to that effect, my lord, because the common condition list.
No,
is
no, you
clear as
can
of yet.
change the law
Yes, my lord.
by giving a reply.
Okay, file his affidavit, my lord, please. Next week, lordship may take up, my lord.
Page 25, Lordship, another important aspect.
Page 25.
25, Lordship.
Yes.
That part of it, disseminate CL number 8, Lordship,
Ah.
otherwise gradation list, Lordship.
Page 25.
8, Lordship, petitioner. The
Yes.
last column, Lordship, remark column. Permission for postgraduate degree not obtained from DHC.
Who?
Petitioner.
Parthi Pratim Goswami. Huh? And then in that case, you are not.
My lord, this is, my lord, I did my MA qualifications from the Krishnakanta Handicap University, my lord. There, my lord, distance mode of
Permission for
educations
postgraduate degree
for
not
distance-
obtained from DAC.
not required, my lord.
Huh?
Not required. Distance mode of education, if I qualify, my lord, is not required, my lord. This is not, I have got that, I have got the, my lord, notification to that effect of the Krishnakanta University, my lord. These are notifications.
Saying what?
It says, my lord, this is to inform all concerned the admissions in ODL program offered by Krishnakanta University. The university on this spot doesn't require any NOC to be submitted, NOC to be submitted, my lord.
Huh?
Not requirement. Distance mode of education is not going to regular class, my lord.
How you, is it, recognized?
Yes, my lord.
Distance
Recognized, my lord.
mode.
Yes, recognized, my lord.
Why don't you fill up it on regular basis?
Of the arrangement basis only.
Because he'll be out.
I think, my lord, I'll be no, my lord. In that event, my lord, they will not continue with the, my lord, selection process, my lord. They're long, my lord.
Had Mr.
What I'm praying, my lord, one thing I'm praying, my
Learned
lord.
counsel for the petitioner.
Till then, my lord, this director may take a call in this matter, my lord, regarding, my lord, finding out the, my lord, since final selection being regular selection being made out, my lord, as done in the other case which I have given, my lord. Till the final selection is not done, my lord, the director may take a call and ascertain the seniority of the persons, my lord, and eligibility of person, then let him determine, my lord. My lord, may kindly see that judgment, my lord, is settled, my lord. Roshi may kindly come to the judgment that para, my lord, may kindly see that judgment, my lord. That para, my lord, 10, my lord.
I have seen it.
10, my lord, para 10, my lord.
I have seen it, sir. G. Alam, learned counsel for the petitioner. A week's time is on the prayer of Mr. Week's time is, learned standing counsel, a week's time is granted to file affidavit in opposition. List the matter after a week. Yes, record it. You filed the affidavit? Huh? Then matter became infructuous.
No, my lord, he is, my lord, he's a president, my lord.
Huh?
My lord.
Okay.
President, my
Who
lord.
is the principal in charge?
Principal is just number 5, my lord.
Behalf of B. He is out of station.
You don't have anything to say. You have nothing to say.
Yes, I do not know about the factual part of the instant case law.
So where then in that case will set aside the impugn order. You don't know anything. You don't have anything to say.
Lordship, matter may be fixed for
After 1 week.
My lord, may I pray for a date, my lord? After.
After 1 week. It will be listed after 1 week.
My lord.
For dismissal.
My lord. My lord, always, my lord.
First, make it fast. We'll finish.
Please, your lordship.
Yes,
On the last occasion, respondent take time for file their affidavit.
yes.
Hello.
Heard MS so learned counsel for the petitioner. Further, on the prayer of Mr.
Standing
Learned-
counsel elementary.
Standing Council Elementary Education. Further 3 weeks time is granted to file affidavit.
That may be fixed. Lordship.
After 3 weeks, with the date.
Obliged.
Obliged.
Lordship, in this case, I have received the instruction, so I have granted 10 days time, lordship.
Heard Mr. So Khandakar, MR Khandakar learned counsel for the petitioner. Further 2 weeks time is granted to Mr. PP Datta learned standing counsel, secondary education to file affidavit. Just next.
May I pay a date, my lord, after
Next.
vacation, 22, my lord, April. 22 April.
What 22 April? We're granting them 2 weeks only. Yes,
I am.
next. Affidavit, yes.
Lordship, we need some time to file our
I heard Mr. So and so. Your name, please.
I'm KJ Secure.
Learned counsel for the petitioner. Further, on the prayer of Mr. MS. For what?
University.
Huh?
For all the respondent, lordship.
For learned counsel for the respondent. Further 3 weeks time is granted to file affidavit. Yes.
Lordship, may I pray for a fixed date, your lordship?
After 3 weeks, we'll see. Let them file first.
57.
Same order. Mr. Khan.
They are supposed to file affidavit.
My name is Khan. Mr. Deep
For 1
Kumania. Further 3
Higher
weeks
education.
time. to file affidavit. Yes,
Any date may be given, Lordship.
3 weeks. We'll see. Let them file affidavit. Uh,
58.
Yes. Affidavit.
This order they are relying on in this case
Ah.
is already under challenge, but not under challenge. We have filed a review petition against that. So that matter is fixed on 1st of April. So this also can come up thereafter, my lord.
Not appears for the petition. Are you appearing? Yes. What do you say?
Review petition has been filed. in
Of
this,
what?
In this case number 4,
They are relying some judgment.
My lord, that judgment.
Okay. As agreed to by learned counsel for the parties, let this method be listed along with review petition number 20 of 2026. Huh?
But review petition issue is different.
We'll see. We'll see. Okay.
Review will go to, my lord, that particular court, I think.
Huh?
Review will go to a particular court review petition. It will not.
Therefore, let it go along with that. Yes.
60. Gentleman, respondent was supposed to file affidavit in this case.
Yes, heard Mr. N. Hawk, learned counsel for the petitioner. Huh? Yes.
Take it to the department.
On the prayer of Mr. So-and-so, learned counsel for the respondent, further 3 weeks time is granted to file affidavit. Yes, next. Yes.
Your Lordship.
Yes.
Lordship, Mr. N. Bora, as senior counsel, even lakes.
Where it is? Where is? IA is for what?
Or regarding payment of area.
No, any instruction?
We have stated that that amount has been released and they were supposed to take the instruction as
Yes.
per the last order dated, Lordship. They were supposed to take the instruction whether they have
He
received.
may be given sometime verify the same from his clients. Yes.
Lordship, Mr. Enbor is in legs. Next, Lordship is coming, Lord.
Any instruction? Have you received?
I have not any risk.
Huh?
But earlier, my lord, at the time of my lord filing this IA, some portion of the month they are released,
They
but
say-
now they are not given.
Huh?
Now again stopped.
How?
Yes, my lord.
No, since they have already to support, there is no pending salary to be released to the prisoner up to month of December 2023.
As per
You are
the
claiming is that
Yes, 23, I mean, 6 months they have paid, but thereafter again stopped. They are all in grade 4 post,
Lordship,
my
that
lord.
is a separate prayer, Lordship. As per the IA is concerned, that amount has been released for that period, Lordship.
No,
IA is
IA 3089.
Up to 20 is said. Court may please direct the response authorities to release the area and currency with effect from
My lord,
September 22, 20 in respect of so-and-so, 23 in, matter ends there.
so-and-so, July, so-and-so, and salary regularly, my lord. Regularly, they are not paid.
And what is the main petition?
Main petition, my
Is
lord.
for regular,
Yes, my lord.
regular prayer.
Regular prayer, they are not irregular. They are going to, my lord. Okay.
Writ petitioners have filed another writ petition claiming similar benefit, Lordship. Lordship, I will get that instruction on the next date. I will get the writ petition number also.
Heard Mr.
That
N.
is
Sharma, learned counsel for the
5540 of
petitioner,
2024.
applicant writ petitioner, on the prayer of Mr. D. Upamanya.
I can be disposed of, Lordship, regarding the main petition, Lordship. That
He
can-
said, TK, you have paid up to 2023,
Yes, Lordship.
but then he wants the regular.
Regular,
salary
Lordship,
also.
they have filed another writ petition, Lordship. 5540 of 2025 with a separate council, Lordship. That writ petition is there with me, Lordship. That may maybe take up along with this, Lordship. 5540 of 2025.
3970. This 3970 is what?
This is an IA, Lordship.
No, IA is 3089.
Lordship 39.
Writ petition is what?
Lordship, this is 3970 and
3970 is for what?
For citizen caused the impugn, my lord, observer of finance department to my lord, later, my lord, for the directing authorities cancel the resign. It, my lord, they have my lord, going to cancel our appointment later, and they after engage a new set of one ad hoc appointment.
That is something different.
That is.
Yes.
You will have to file again. He said that this set of the other set of counsel filed and everything. Heard Mr. N. Bora learned counsel for the petitioner. Decision applicant, and also heard Mr. D. Permanent learned counsel for the learned standing counsel, higher education department. Decision application. Praying for release of area and current monthly salary oblique wages with effect for month of September 2022 to July 2023. In respect of the petitioners, huh?
No.
Applicants. Next para. Mr. D. Upamanian, Land Council for the Land Standing Council submits that there is no pending salary to be released to the petitioner up to the month of December 2023, as the applicants have been paid with the salary till December 2023. Next para. Considering above, this court on 06/02/2026 granted time to Mr. Land Counsel for the applicant to obtain instruction. Today, next para, Mr. N. Bora Land Counsel for the applicant submits that although salaries oblique wages up to December 2023 has been paid, however, no current salary has been paid. Next para. Paid to the applicants, huh? Next para. Having considered that the prayer in the specific prayer in this application is for release of the area salary oblique wages till July 2023, and considering that no area salary oblique wages are pending to be released to the applicants, I deem it appropriate to close this IA, huh? Next para. With a liberty. No, accordingly, the IA stands closed, huh? And disposed of. However, liberty is granted to the petitioner to approach, to file any application or petition claiming release of the current salary.
Right.
If so advised.
Right, sir.
Then writ petition, list the matter after, in writ petition, huh? Then writ petition read, heard so and so, same, huh? You have filed affidavit here. Have you filed affidavit?
No.
On the prayer of Mr. Heard so and so, karke na? On the prayer of Mr. D. Upamani Lani standing us, for that 3 weeks time is granted to file affidavit, huh? Then next. Huh?
Much obliged.
The last bit. Yes, 62, 63.
My lord, I think your lordship is.
Yes, the affidavit is filed.
Yeah, everything is filed. Only thing, my lord, if your lordship looks at the last order, my lord. Last
Office
order.
not indicate petitioner has not taken steps for service, huh?
My lord,
Petition for
earlier order to that, my lord.
is allowed to serve notice to respond. Have you
Everything is done, my lord. That would your lordship be pleased to see the order dated 25/2/2026?
Yes. What is this?
My lord, last page, my lord. That was the
projection made is respond to file their counter on or before next date, and an attempt would be made to dispose of. Today is not possible. Who is for the respondent?
No, I understand. My lord, only thing is that considering the above position, if your lordship has seen that. My lord, urgency.
Have you filed the affidavit?
They file, very urgent.
Okay, next week.
No, urgent, very urgent, my lord.
Next week. What is the urgency?
Urgency, the man is hanging. This is the transfer order.
Hanging?
Man is hanging.
Okay. I said man is
No.
Huh?
No, the entire thing is that challenge to the order of transfer by the deputy commissioner.
Friday. as agreed to by learned
My lord,
counsel for the,
Wednesday,
huh?
Wednesday.
Then Thursday. Thursday, make it Thursday. As agreed to by learned counsel, Mr.
Jiabedin.
J. Abedin and MS S. Learned Standing Council for Elementary Education, list this matter on Thursday, I 19 so and so so and so.
My lord, only one thing. my lord. Could it be Wednesday?
Why?
Because suppose if the Eid is Friday, then I'll run my native Thursday, my lord.
Are you,
Rosa,
are you inviting for Eid to us?
Definitely, my lord.
First you invite, then we'll take up the matter.
My lord is invited already. My lord,
Okay, okay.
Wednesday.
Make it Wednesday. Transfer posting,
Yes, yes.
dismissal, huh? For dismissal on Wednesday.
Yes, yes.